Lordships, my lord, may I be permitted to mention this, my lord, that as I matter, Lord, it's a appeal from contempt. The contemner has been hauled up in contempt. Lord, Friday is the returnable date before the Honorable Single Bench. Even the assignment also has been done on urgent basis upon mentioning before Honorable Chief Justice. Lord, she kindly give a chance, my lord, at least, if not today, tomorrow. So that we can.
Papers are available, it will be
Papers
listed
are available.
tomorrow, we'll see.
Papers are available, Lordship.
We'll see.
Kindly give the contemner a chance, my lord, to plead with your Lordship, my lord. Tomorrow,
Contempt rule has been issued.
No, he has been held in
held in contempt.
Yes.
And
Punishment
returnable
given 15,000 as fine.
Yes.
That is to be reflected in his service record.
And
to
Friday has
not,
been
not
Friday
paid.
has been fixed for compliance.
Yes, since
report.
not paid. So yes, that has been revived. Friday is the date for Lordship. Kindly give me a chance to me, Lord.
We'll see. Let it be listed. We'll see.
Why our orders are not being complied with?
Orders complied with. Lordship was happy, but why delay? On that delay point, contempt. What he was not happy with. Only for delay.
Why? Which is the regular bench for appeal?
Regular bench is the similar. It's an order by Justice Mantha. So content appeal is before the same day.
Very well. Let us see.
Lordship.
Inclusion, just hand over the slip. Do not mention. Do not mention. Just hand over the slip.
Your Lordship, may I permit to mention a matter? Your Lordship, item number 70 and 71 was initially taken up on 6th by your Lordship.
70 and 71.
Yes, it is a NIA matter.
Yes.
I'm led by Mr. Shobhushaji Banerjee in this matter. It has been directed to keep on the top of the list in the bail matters heading.
70.
On 6th of November 2025.
NIA bail heading top.
NIA
it is at the top of the NIA bail. Next. Can't hear a word of what you are saying.
Lordship, I am seeking the leave of your Lordship to file for the leave to file one.
When was the order passed?
Lordship, the leave without the certified copy, with the true copy of the order judgment. That
what we are asking, when was the order passed?
Lordship, order was passed on July, your Lordship.
Not granted then.
Lord, with the leave of
why haven't you applied for certified copy?
Lordship, this is the true copy, Lordship. I am seeking the leave to file with a true copy that has been handed.
Why should we grant you the leave?
Lordship,
why don't you have a certified copy
Lordship,
till now?
The difficulty is that, my Lord, the appellant is in custody for more than.
You are not answering a question, sorry.
My Lord, with the leave of Justice Shinara, I may be permitted to mention, my Lord, the Ramswarup matter, which was fixed on Friday, my Lord. On last, it has appearing in the list that it will be taken up, my Lord, tomorrow, as it was fixed on last Thursday on 14th. My Lord, because of inconvenience of Mr. Bachawat, my Lord. Today, my Lord, the list has come that it will appear tomorrow at 3.
It is there in the list?
No, my Lord, my Lord, with Justice Rai, the bench. Sure. Yes.
What is the problem tomorrow?
It was since Mr. Bachawat has it was mentioned Mr. Bachawat has a matter fixed at 2. It will take the entire day. I mean, he was to argue, my Lord.
Please understand, this is a special bench that has to assemble.
Yes.
And we can't do it at your convenience.
I understand, my Lord.
Friday, that bench is not available.
Any day, my Lord, subsequent, my Lord.
Where's your other side?
Lordship.
Yes.
You're for the appellant, your Lordship. Then, your Lordship, your Lordship has
then it has to be next Thursday week. What to do? Either you oppose their prayer, then we'll fix it on Thursday tomorrow, or you agree, then we can fix it next Thursday.
Then, Lordship, Thursday week.
Thursday, next Thursday. Thursday next week করে দিও. Thursday week ওই তিনটে ফিনটে সেটা কথা বলে নি. Sir, if next Thursday senior counsel is in difficulty, please be prepared to argue. This is not fair.
We shall.
চলো রাখো।
10:30 fixed matter.
Have a kind leave to mention a matter. This is a group 9 appeal.
Give it. Yes, Mr. Chatterjee, what is your stand on this?
May I?
31.
Yes, Mr. Chatterjee.
But I also do not wish to place on record.
Manuel, kindly.
Yesterday, the appeal was being heard substantially by your lordship, and not despite that, this is what is issued by the department, the state. Lord, the financial evaluation sheet has been recalled, complying with the order of the learned trial judge. This is the order. 11th yesterday evening, this was served.
May I?
Is that fair? Is
Sir.
that fair?
Milord,
To start with, is this fair?
Milord, I'll say, Milord, no advice of us were taken before this.
We'll stay this immediately.
Well-
I'm not on the.
দুটো কপি আছে ওতে, ওদের দুটো কপি।
The date, the inquiry has to the date of affirmation of the affidavit and the service of affidavit. So this term date will indicate. Another one.
Inferior copy আর superior copy আছে।
But we will get the dates and another factor. Which will demonstrate collision between the state and the private respondent. Mother will I'm sorry,
Yes.
kindly take page 477. Once more.
477 টা কোথায় আছে দেখো।
Paper book.
Stay petition.
Stay petition.
Volume. Volume 4.
তোমার পাতাও খুঁজে পাচ্ছ না? কোন তিনটে করে উপরে লেখা থাকে কোন পাতা থেকে কোন পাতা?
দেখুন না। এই দেখেন।
উল্টো দিকে দেখছো, খুঁজে পাবে কোত্থেকে?
অলরেডি মার্ক করা আছে। 73.
Yes.
Lordship will find this is the minutes of the meeting of this tender evaluation committee.
Yes.
These minutes is not a public document. These minutes were not uploaded in the public domain. These minutes have been interestingly annexed to the affidavit in opposition filed by the private respondent when these minutes are clearly confidential document. And that we have stated in our reply, I argued this point at paragraph 11. That the state, the state it's like that. Opposition.
ডেট হয়ে গেছে তো, অপোজিশন তো অ্যাফার্মড হয়ে গেছে, কোর্টে না ফেল করলে কি হয়েছে?
These minutes. How the appellant got access to this.
Yes, Mr. Chatterjee.
Milord, until Milord, yesterday, Milord, I was wishful of arguing and deliberating before my lords compliance of clause 39. Milord, I was wishful, Milord, of arguing that, Milord, on the allegations in the writ petition remained on the date when the draw happened, wherein, Milord, the appellant before your lordship has participated with open eyes. He did not challenge at that stage that
Appellant.
appellant has also participated in the draw, my lord.
Yes, yes, correct.
The writ petitioner respondent. I'm sorry, my lord. The writ petitioner, my lord, respondent had participated in the draw with his open eyes, my lord.
Yes.
On being unsuccessful, my lord, he is challenging.
Correct.
Lord, I was wishful of arguing, my lord, again, my lord, that your lordship has laid down the law that in tender matters, it is the author of the tender who is to judge the terms and see if the compliance is made or not. But what has troubled your lordship has troubled us and, my lord, to a greater magnitude. My lord, this affidavit thing has troubled us to a greater magnitude. My lord, we are unable to, my lord, answer as to how this has happened. Lord, my learned junior has confirmed to the fact that this was drafted by the department. Seldom, rarest of the rarest matters, 1 in 100, my lord, we get a drafting from the department, and we see if the format is okay or not. And my lord, he has taken steps for affirmation of the same. My lord, we did not serve the private respondent. Milord, the affidavit, Milord, was affirmed on, Milord, 5th of August 2024. It was served, Milord, on the writ petitioners on 26th of September 2024. Milord, it is shocking to us also, Milord, that the affidavit of the private respondent is absolutely in toto with the affidavit filed by the state. Milord, state, Milord, has acceded to the order, acted in compliance, your lordship has seen the corrigendum.
Corrigendum may or may not be justified, but that was not proper when we are hearing out
Absolutely, my lord. We were not discussed or taken advice of before issuance of such.
So we are staying the operation
My lord,
of that,
kindly
the
do that.
disposal of the appeal.
I will kindly do that.
Appeal may be dismissed, may be allowed. That is a different fact. You immediately inform over telephone, no effect should be given to the corrigendum.
Absolutely, my lord. Immediately. We'll do
Right.
that. We'll do that, my lord.
And yes, what is your otherwise any other submission? No.
No, my lord.
No submission.
Now,
yes,
May I just take 2 minutes of your lordship's time?
1 second. Yes, Mr. Kaur.
Lord, on the argument of Mr. Mojumdar, first was with regard to variable cost. Lord, he is vehemently argued that, Lord, the cost for the gas, cooking gas, should be a variable factor. And he's not relied upon clause 5 of the tender conditions. Would your lordships kindly, Lord, take page 43, kindly take volume 1 and come to page 43. Lord, I just take 2 minutes because this concept of variable cost is nowhere in the tender condition. This is a new concept which is to be adopted, and learned judge rightly rejected that contention.
No, we have noted your point.
Yes, I just wanted to show your lordship.
That is all right. What is troubling us?
No, I'll address that, Lord. I'll just address that. Clause 5, if your lordships will not kindly take sub-clause 4. Sub-clause 3, my learned friend has read. The cost of cooking gas is fixed as per first volume, Lord. First volume. Page 43. It's 43 and 29.
43 ভুল করেনি, দুরকম page number.
Yes, 43 and 29, Lord.
Yes.
Lord, kindly take Roman 3, my learned friend read. The cost of cooking gas has been fixed at 6.15 per head per day. Then 4, Roman 4, the rate offered should be consolidated. A, cost of raw materials. B, cost of cooking gas. C, service charge, including profit and taxes, if any. So, Lord, if there is a consolidation, where is the question of variable, the concept of variable blood cost fitting into clause 39? Lord, if your lordships now looks at clause 39, your lordships will find that at page 48. Your lordships will find there is no concept of variable cost. It's a new concept which is argued, and Lord, rightly not considered by the learned trial judge. Mode of calculation of rate, your lordships will find it says calculation of rates of acceptable bidders will be on the basis of overall monthly financial. So, my lord, notional cost, variable cost, on the contractual terms, my lord, these are alien, completely alien. And my lord, the entire argument has been made on that basis. My lord, my humble submission is, your lordships will find from the impugned judgment, the learned judge has not considered this. Learned judge has only proceeded on the basis that, Lord, the cost is not reflected in the court.
Separate cost.
Now, Lord, on the, sorry.
Separate cost.
Separate cost. And this separate cost is not only reflected, now the argument is it is not variable. It has to vary from tea, morning tea to lunch to dinner tea, etc. Where is that clause in the tender? Lord, my learned friend wants reassessment in terms of clause 39. If your lordship reads clause 5 with 39, there is no concept of a variable cost in the tender. It's alien to the concept. And Lord, what happened in Bandel, or Lord, what happened in the other place?
Maniktola.
Shalda is Shalda. We do not know what are the terms, how they have read it. It's after all, my lord, it is the employer's prerogative in a commercial contract. Now, my lord, I come to the affidavit point.
Oh, this is they have given effect to the single judge's order.
Single judge's order.
Very well.
While the appeal is being heard.
Very well.
Now, my lord, on the question of affidavit, I just have two sentences.
Yes.
First is, Lord, kindly see the dates. Who has copied whom? This is one aspect of the matter.
Doesn't matter. Somebody has copied somebody.
Right. Whether that has an impact on the grant.
That is a different question.
On the grant, which came much, much earlier. And as on the date, Lord, copying, there was no conflict of interest between the state and the successful bidder. Lord, I can understand, Lord, these are pre-grant situations. This is post-grant. After the writ petition is filed and challenged, when there is no conflict of interest between the state and the purchase and the successful tenderer. So, Lord, where is the question of any collusion? The challenge is to the grant. They have not been able to produce a single, Lord, instance or any collusion at the stage of the grant. Even the lottery which was held, that was videographed. And Lord, state has the video today to show that each participant had consented to the lottery and they participated in the lottery.
That we have.
Let call for the video and your lordship can look into the video, how the lottery was held.
Yes, that is all?
That is all. I'm
You're reserving judgment, Mr. Mujumdar. Chole gaye. Reserving judgment.
But kindly, my lord, say this.
Well, we have already told them to not to give effect to this contract.
Yes, yes. 477, what do you say? He says, Mr. Mujumdar says, this is a confidential document, not uploaded.
But the law is well settled. I may have stolen the document. So long the authenticity of the document is not under challenge.
He is trying to show the atat. That's all.
Lord, atat, what he is trying to show, post 477, he participated in the lottery. Kindly call for the video. That's why I said 477 is insignificant.
All right. All right. Hearing Mr. Kaur, learned senior counsel representing the appellants, hands over copy of, hands up to us, copy of a corrigendum dated November 11, 2025, issued by the MPOs, M.P.O. -cum Superintendent ESI Hospital, Kolkata, which really gives effect to the order of the learned single judge, which is impugned before us. Stop. not a little surprised with this. Stop. The state is aware that we are hearing out the appeal. Stop. On that understanding, we did not consider passing any interim order. Stop. It was most inappropriate, to say the least, for the state to issue the said corrigendum at a time when the appeal was at a time when the appeal is being heard. So, paragraph. Mr. Chatterjee, learned State Counsel, tells us that prior to issuance of such corrigendum, no advice from the concerned lawyers was obtained. Paragraph, be that as it may, we stay the operation of the corrigendum, aforesaid corrigendum, till disposal of this appeal. Paragraph, we have heard all learned counsel, and hearing is concluded. Stop. Judgment is reserved. Party daraj ki. It won't be long. I've already recorded the submissions, so it won't be long. No. The pressure is tremendous, Mr. Kaur. So at times it becomes 4 weeks or 3 weeks. We can't help it.
So far as your lordships are concerned, Lord, I have seen, Lord, it's never too long. In fact, the
Yes.
That's why I suggested that yesterday I made this.
All right. Corrigendum is taken on record.
Item number 1.
Number 1, my lord, I am for the appellant led by Mr. Jantanan Chatterjee. My lord, my one humble submission before your lordship. My lord, I have filed an application for relaxation or modification of the condition of the bail, my lord.
Cran 2.
Yes, my lord. Petitioner is the 72 years aged senior citizen. He has undergone some surgery, my lord, and the condition was given that he has to appear before the learned Chief Judicial Magistrate Purulia once in a month. My lord,
You are for the state.
I am for the CBI. I am led by Amojit.
You are for
Item number 2.
in item number 1, my lord, he is
CBI, I see.
yes, my lord. My lord,
There are 2 appeals. One CBI's appeal, one your
yes,
appeal.
my lord. Yes, my lord.
In your appeal, sentence has been suspended
Yes, my lord.
on certain conditions.
Yes, my lord.
You want relaxation.
Yes, my lord.
Let it be listed under the appropriate heading.
Yes, my lord, and kindly call for a report, my lord.
Heading.
He is appearing before the learned court below, and my lord,
Code below. That
is-
was the condition.
yes, my lord, once in a month.
I see.
And his hometown is in the Lake Town, my lord, which is far away, near about 209 kilometers from Purulia. This is the reason, my lord, we have prepared
He has
this.
been convicted.
Yes, my lord.
Okay.
Imprisonment for,
Commission of what offense?
my lord, 306 and 330 of the Indian Penal Code.
For us, item number 2 concern, my lord, CBI papers appeal against Calcutta.
ঠিক আছে এখন এটা নিয়ে কনফিউশনটা এ করবো না সেটা থেকে
কন্ডিশনটা কি আজকে তোমার ওটা হবে না কি?
ঠিক আছে
এটা কি বল? এটা বলছি তোমার কিউর করা যাবে না। Exactly. Some documents are missing. Is it not without the signature of learned trial judge? No. He does not know anything else what can be done. ধরো এরকম মিস হয়ে যায় তো আমরা ওখানে একটা দুটো সই করার আগে এটা মিস হয়ে যেতে আবার ট্রান্সফার হয়ে চলে তাহলে কি হবে তাহলে যিনি জজ সাহেব থাকবে সেই জজ সাহেব কি করে একটা অর্ডার শিট করবে যে এটা ছিল না এই ডাইরেকশনে আমি করছি সিগনেচারটা এই ডেটেড সিগনেচার এইভাবে এটা হবে তো এটা কি আমাদের পার্টিসিপেট প্রয়োগ করতে হবে না ডিফেক্ট নিয়ে সেটাই কি করতে না পাঠাতে হবে পাঠাতে হবে এবং বলতে হবে ডেটেড সিগনেচার হ্যাঁ করতে হবে ঠিক আছে আমি লিখে দেবো
Look, the records are the TCR is still defective. Initially, when the TCR came to this court, it was examined and it was found to be incomplete. Some documents were missing. So it was sent back to the trial court for curing the defect by supplying the missing documents. Now the trial court has sent back the TCR with a note report that the documents missing cannot be found. Documents are missing and error will not be rectified. Additional signature.
Have been marked without the signature of the learned trial judge. Exit 21 have not been received with the case record. Have not been received. আমাদের এখানে পাইনি however learned reasons for not including in the case record হবে না তাহলে মানে এ করতে হবে মানে এক্সপ্লেনেশন কল করতে হবে করে এটা পাঠাও বা কি হয়েছে একই রাখো পরের দিন আমি আজকে রেকর্ডটা দেখে নিই ঠিক আছে
Very well. Let the CRAN 2 of 2025 be listed under the heading relaxation of conditions of bail. আর এটা দেবে তুমি বেলের আগে, bail in connection with appeal এর আগে দেবে. When? Day after tomorrow?
My lord, yes.
Friday date দিয়ে দাও. Who is for the state in item number 1?
My lord, CBI, Mr. Omajit.
CBI, sorry. You are not appearing, item number 1?
Item number 1, I am not appearing.
Yes, my lord, I have served the PRAN application,
Can
my
they
lord.
be in 2 you are appearing for CBI, in 1 you are not appearing?
I think it's not properly instructed, but I have served the CRAN application upon Mr. Omajit De.
Then talk to him, ask
My
him
lord,
to be here.
I will again serve the notice.
Ask him to be here on Friday. It will be fairly at the top of the list.
Grateful, lord.
এই এটা আমার কাছে রেকর্ডটা পাঠিয়ে দাও তো রেকর্ডটা পাঠিয়ে দিতে হবে পাঠিয়ে আমি আজকে দেখে মোটামুটি
পরশু দিন বলতে
হ্যাঁ মনে থাকবে তো এইটা সময় পাঠাবে হয় নাকি কেন এরকম
পাঠান
দুটো সেকেন্ড ডেস্ক কপি পাঠিয়েছি আইটেম 3
Appearing for the applicant, madam. This matter is appearing for department report as incomplete.
অ্যান্সারটাই লিখি তো আমরা বুঝতে
এটাই জিনিস Again, some documents are missing, so defects can't be cured. We'll keep it day after tomorrow, sir. একই জিনিস দেখে নাও
এইটা আমাকে পাঠিয়ে দাও তো, এইটাও পাঠিয়ে দাও। ভাবতে হবে আগে। হ্যাঁ,
ওই জাস্ট লিস্ট প্রসিডিং লিস্ট করে দাও, কিছু না। অর্ডার করার দরকার আছে?
আমার কাছে যেন যায়। আচ্ছা, এখন
না
যেন পুরো কমপ্লিট থাকে।
সব
দুটোই পাঠিয়ে দাও, দুটোই।
না না
এই দুটো ওনারটাও আমাকে
দুটো কপি পাঠিয়ে দাও।
সেটা দেখা গেল যে হচ্ছে আর কেমন।
item 4 নেই
Court on its own motion, rule was issued.
Yes,
What
sir.
for? দেখি দাও ফাইল দাও।
This matter, Your Lordship, where the appellant, while pleading his case, has stated that his mother-in-law and father-in-law were acquitted. So he said he had submitted that they stand on the same footing with the appellant. Hence, the appellant should also be acquitted. So that is why the court was called issued.
এই 119 সেট বাকি তিন নম্বরের বাকি
অ্যাকিউটেড হয়ে গেছে।
হ্যাঁ, কিন্তু অ্যাকুইটেড হলেও যেহেতু অ্যাপেলেন্ট বলেছে যে they stand on the same footing as the appellant and appellant has been convicted, therefore notice was issued by the court to the acquitted father-in-law and mother-in-law. Appellant is the husband. So in spite of service of rule, they have not come. Therefore, we'll direct the jurisdictional police to secure their presence.
So the appellant was just here, Your Lordship. I don't know.
Not appellant, the
Yes, Your Lordship. The rule was-
in-laws.
Laws.
Rule has been served on the in-laws.
Yes, Your Lordship.
ঠিক আছে, ঠিকই বলেছে। আবার এলে বেলে ছেড়ে দেওয়া হবে। So it is a one person was convicted
Yes, Your Lordship.
and
Husband.
another 2 persons were acquitted. So there is there 2 appeals?
No, Your Lordship. Only
Again, one against everybody is. Oh, you are filing one affidavit. Appeal against acquittal.
No, Your Lordship.
So
The appellant had preferred an appeal.
appellant has preferred.
The appellant who was convicted, that is the husband, he had preferred one appeal, Your Lordship.
Yes.
During the pendency of that appeal, within that only the rule was issued. Because the advocate appearing on behalf of the appellant had submitted that the persons who have been acquitted, they stand on similar footing with the appellant. So why will, so that is why, Your Lordship.
So there is no appeal against the said acquittal
Yes,
by
Your
the
Lordship.
state.
No, Your
So,
Lordship.
whatever you claim.
It was on the thing of the appellant that their lordships were pleased to issue rule, Your Lordship. Because he was adamant that why will not the appellant, if standing on same footing, be granted?
যদি হয়ে থাকে তাহলে তো স্টেট provision can এখন ছিল না হ্যাঁ তবে সিকিউর প্রেজেন্স করে অর্ডার
The rule was issued by a coordinate bench on 7th July. Just check. Hey,
On
Mushibam,
7/2025.
7/7.
7/7.
7/7. Hey, Lekho. A coordinate bench issued rule against Dinesh Rajok and Parul Rajok, comma, two co-accused persons who were acquitted by the learned trial judge. Stop. This was because the appellant, in course of hearing of the appeal, insisted that he is entitled to reversal of the order of conviction since he stands on the same footing as the aforesaid two persons who were acquitted. Stop. Paragraph. From a departmental note dated,
My lord,
you are appearing.
no, I am not for the appellant. Another co-accused who has been acquitted in the trial court.
You are appearing for the Rajok, Parul and Dinesh.
Yes,
That's what we are asking. We know you are not for the appellant. What do you say? The rule was served on them.
yes, yes.
Where are they?
They last occasion they appeared, and I have already filed my.
Anyway, এই rule টা তোর contempt rule নয়, এটা personal appearance এর দরকার।
So you are appearing on behalf of
You are appearing.
those acquitted.
So what do you say? You see, a coordinate bench issued this rule because the appellant is not here today. Who is appearing? Do you know for the appellant?
Mr. Dattagupta, Tapan Dattagupta is appearing for the.
The appellant insisted that the acquitted persons stand on the same footing as the appellant. Therefore, the appellant should also be acquitted. Or your client should also be convicted.
And realized upon one decision.
Decision.
So you come back with.
Come back, be prepared, prepare yourself.
Give your appearance.
Sure, লেখো।
Give your appearance.
কি লিখেছি? Dated September 4, 2025, we find that the rule was served on the aforesaid Dinesh Rajok and Parul Rajok. Stop. Learned advocate appears for them today. Paragraph. List this matter once again. The appeal was being heard.
Yes, Your Lordship.
Under the appropriate heading, appealer heading ही देवे. 1 week hence.
1 week hence.
1 week hence.
Very interesting case.
Amongst the first 5 items. Amongst the first 5 items.
So what is your
Paragraph, a second. Since the appellant is not represented today, comma, learned advocate for the state is requested to communicate this order to learned advocate appearing for the appellant. এবার বলো কি বলবে?
No, so you are ready with your submission. You are ready with your submission.
No.
Not ready.
Just I have been ready.
Okay, and you?
Yes, Your Lordship. And this was on the midst of the entire appeal was finished.
Go through that judicial decision first. There is a judicial decision mentioned in orders dated 7/7. So you please go through that judicial decisions.
Yes.
You know,
The appellant is
Appellant is here,
Yeah.
but I'm the appellant.
Then Your Lordship, I don't have to communicate since he's appearing.
Come back after 1 week. We have listed it for hearing of the appeal.
for the appellant.
What do you say, that you should be acquitted or his client should be convicted?
His client cannot be convicted right now. Since once they have been acquitted,
So therefore,
I shall argue on this one.
so you should be acquitted.
I should be acquitted. My argument was
That makes sense. Yes, if you can show that you stand on the same footing.
Yes, I shall try to visit your lordship. Then my innocence of all that matter, as your lordship.
Sure. Next.
My lord.
How are you say?
appearance नहीं ना hey तेरे last line तो दियो ना
Item 5, 6,
चलो चलो
7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20.
second call
Second call. Item 5.
এসো একটা বলে দিই this is a very old appeal of 1963 stop the appellant has taken no step for hearing of this appeal stop obviously he is not interested in proceeding with the appeal paragraph in the first call nobody appeared for the appellant stop in the second call also nobody appears paragraph MA such and such is dismissed stop interim order if any stands vacated
6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Item 24.
Mr. Novelty has been appointed from the legal aid to represent the appellant. Lordship, we intend to file the memorandum of appeal. If Lordship kindly grants some time. in the
memorandum
meantime-
of appeal
Yes, it's a jail appeal that has been filed from the legal aid. Now we need to file the memorandum of appeal.
I-
Lordship kindly grants some time. In the meantime, we shall file the memorandum of
how long 2 weeks
1 week. Shall be
1
enough.
week learned advocate appears and says that your senior
Mr. Novelty Day, Your Lordship.
says that Mr. Navonil De, advocate, has been appointed by the legal aid to represent the appellant in this jail appeal. Stop. He seeks a week's time to file a formal memorandum of appeal. Paragraph lists this matter under the same heading. 1 week hence.
Grateful, Your Lordship.
19 তারিখ 25.
চলো
নো অ্যাডভোকেট লেখা আছে
no advocate লেখা আছে।
ওটাও খেয়ে নে। তাহলে তো একে ডাকতে হবে তো লিগাল এডের কাউকে করতে হবে কাউকে কি হবে কাউকে
কে অ্যাপয়েন্ট করে কে লিগাল এড মানে হাইকোর্ট
দাসগুপ্ত আছে দাসগুপ্ত আছে
মিস্টার দাশগুপ্ত Mr. Chengupta. This no advocate means this is a jail appeal. So advocate has to be appointed. What do we do? Whom do we direct to appoint advocate?
For the appellant, my lord.
ওই দেখো you have been appointed by legal aid. Memo has been filed.
Memo has been filed.
We'll admit the appeal then. We will admit the appeal.
Yes, my lord.
Appeal against conviction under what?
Well, I'm not holding the brief, my lord.
Goju?
Give me any time next week. I'll just appear in this matter.
We'll admit the appeal if you tell. কাগজ আছে কিছু? কিচ্ছু নেই।
মেমোরেন্ডাম অফ অ্যাপিল
There is no memo of appeal.
My lord, my senior, Mr. Ramashish Mukherjee is appearing for this matter, my lord. Gives me some time, I'll
Not this week.
grateful.
appearance নিয়ে ভালো হতো
এই পালিয়ে গেল।
appearance
On the request made by
staff
learned advocate for the appellant, let this matter stand adjourned for the week.
this week. 26.
Lordship, for the appellant, Lordship. It's filed within time, Lordship. Judgment and order dated 17/7/25 and 18/7/25 respectively. Conviction under sections 448, 323, 324, 325, 326, 506 and 34 of the Indian Penal Code.
This is an appeal usual. This is an appeal against an order of conviction. Very usual. Appeal is admitted, etc., etc.
Admitted.
admission হলো তো sentence না অলরেডি আছে পেয়ারে লিখে রেখেছি ঠিক আছে হ্যাঁ না অ্যাপ্লিকেশন নেই এটা পিটিশন অফ অ্যাপিল এটা লেখা আছে পিটিশন অফ অ্যাপিল সিভিল
27.
Appearing for the respondents in this matter, my lord.
My lord, I am appearing for the appellants, my lord. May I be permitted to appear online, my lord?
My lord.
Why?
My lord, because of the, my lord, I'll be very candid, my lord, because the list collapsed, my lord, by the time I would have reached the Honorable High Court, my lord, I would not have been able to make it, my lord.
My lord,
if my lord gives me five minutes, my lord, I'll be there.
Because it's impossible to hear you like this. Yes.
My lord, Mr. Rajoshi Datta is also appearing in this matter. He's on his legs before Justice Roy, my lord. In that event, if my lord kindly keeps it after 20th, or I can place this matter, because in this
What
matter, my lord.
20th. He's for the appellant. Why after 20th?
My lord, it gives me a my lord will only give me a 5-minute pass over, my lord. I will just run and come.
Pass over.
28.
This was the same submission that was made on the earlier occasion. Mr. Bishwarup Bhattacharya is leading me, my lord.
Your lordship, in this matter, Mr. Dheeraj Trivedi is appearing for respondent number 126. He's coming, your lordship. I'm praying for short passover.
Passover?
Wait.
Hmm.
29.
I appear for the appellant. May I pray for a short passover, my lord?
I'll make it not today, my lord. One thing, my lord, I was the added respondent before the learned single judge. But here, my lord, I have not been served with the copy of the appeal or the application.
You were formally added?
Yes. I'll take steps
Sir,
of my lord.
Sir, not today.
Not today. Item 30.
Item 30, my lord, I am appearing for the respondent number 123. My lord, Mr. Shubhish Chanel is here, my lord. He's as well as our leader, my lord. My lord, kindly, he requested me to pray before your lordship to fix it on Friday, my lord. He's then
Talk to Mr. Shorkar.
He yesterday
Counsel
said
was here
he'll
yesterday.
be appearing today.
Talk to Mr. Shorkar. Why are you looking at us?
my lord, just now, my lord, just 5 minutes back, my lord, I have informed.
He's not appearing alone.
You persuade him. It is embarrassing for us.
Persuade him. If he agrees,
I
no
should have,
problem.
my lord. I should have.
আবার আমাকে বলছে।
But kindly keep it on Friday.
বুঝতে পারছেন? So difficult. Actually, first item on Friday. First item under this heading. First item. Accommodation is paid for on behalf of CAC Limited.
Not
CST.
PSC, IPCL.
IPCL.
India
Power Corporation
Power
Limited.
Corporation Limited.
Indian Power Corporation.
India.
India Power Corporation Limited. Paragraph. Let this matter be listed as the first item under the same heading on Friday.
Friday. Okay.
তো হয়ে গেছে 31 তো 32 নাম দেয়নি
32 to 36 actually.
32 to 36 হ্যাঁ 32 to
तो नहीं हम की बोल
32 to 36
This CRAN only in 34.
yes madam. And I am for the defect complaint.
State.
Who is appearing for the state madam?
I haven't seen him today. Has he come?
Yes, sir, he has come. Yes.
Get hold of him. Get hold of him. We'll pass over. Once you get him, we'll take it up. Without the state, how can we proceed, Mr. Sinha?
No, de facto is there.
Yes, de facto may be there, but state also has something to say.
But your lordship will hear me.
objection
De facto is not opposing.
No, yes, yes. My lord, vehemently opposing. My lord, thick side. My lord, let me start, my lord. If
How long will it take? If you start, it will finish immediately. Ask your junior to call him, Mr. Shur. We'll take it up. You get him, we'll take it up. Don't worry. Hey, Mr. Remind us once he is here, we'll take it up.
so you are not appearing in item number 32 you are not appearing
no, my lord, only CRAN application is in 34.
so
32 to 36 action দিয়েছেন board
32 to
32 to appeal. Application actually 34.
Separate for 5 appeals from the same judgment. CRAN is in the one.
Application আছে for suspension আছে নেই ওগুলো আবার appeal হেডিং এ চলে যায়
ঠিক হবে ঠিক হবে
আমি জানি না দিতে হবে বেল দিতে হবে
না 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 না
হ্যাঁ কানেক্টেড তো সেখানে অনুলোগাস বলে একশো কি হলো
আর ডাকতে হবে এটা ডেকে দিয়ে 37
Lordship of the appellate.
কি কোনো কপি আসেনি
Lordship, I'm led by Mr. Anand Keshri. I have already informed him he's on his way. Lordship, I will take notes. Let him start.
yes
because yesterday's matter no
Yes, Lordship.
so that is client declaration is 164
Just pursuant to your Lordship's direction, I inspected the evidence file. And
oh that 164
yes, Lordship. I have inspected the file.
Okay,
I went through as to the best of my ability given the paucity of time. Lordship, I am convinced that there are certain materials which I need to bring to your Lordship's notice that will help my argument.
yes sir please remember we are not hearing the appeal
No, Lordship.
so you can't argue for 1 hour
No, Lordship. Just prima facie.
yes
Just a few things. And for that, just to assist your Lordships
do you have the 164 statement have you found it
in the file.
you have you tagged it can we see it no exhibit file
what is the exhibit file
I'll save your Lordship's trouble. It repeats in kind of the similar fashion what
in the dying declaration and the 160 was same
similar.
Uh,
Why the 164 was not considered possibly is because it was taken on the 19th and the doctor certified that on 18th the health of the victim deteriorated. Possibly that is the reason for it. But from the judgment, even though the judgment refers to the 164 statement, I couldn't find a reason why that was not considered as a dying.
That is different. What is the statement of the victim before the judicial magistrate? Whether it is similar with a dying declaration?
7. If your lordship recollects, point number 7 in your lordship's paperwork.
Yes, yes.
That was for your lordship's consideration, that the husband poured kerosene
and set her on fire.
Yes, lordship. On this point, lordships, I would just rely on 2 judgments and briefly make my case. The 2 judgments, lordship, almost same facts, identical allegations.
These were
One is
these decisions were pronounced at the time of final hearing, not at the time of taking bail application during hearing of the appeal.
subject to
Yes,
correction,
yes,
lordship.
yes. Tell me.
What fell from your lordship that the only consideration at this point in time is the dying declaration.
Yes.
And if the dying declaration is the sole basis for conviction.
Yes, there are judicial decisions. If it raises confidence in the minds of the court.
Exactly.
Yes.
I cannot. The lordship knows better.
No, recently I have given a judgment only on the basis of dying declaration.
Absolutely, lordship.
Recently.
Absolutely.
Sir,
Justice.
paragraph 12. In this case, the deceased gave 2 statements which were totally inconsistent.
In this case as well, lordship.
Where is the inconsistency? You just now said 164 is more or less same as the dying declaration.
When the victim was admitted, she told the doctor, admitting doctor, who has deposed under oath.
So you are on bail. We have given you sufficient liberty during trial.
Lordship,
Now you have been convicted.
Lordship, the victim stated that she herself stated before the doctor at the time of admission that she suffered accidental stove burn injury.
Fire. Dying declaration or?
At the first instance when she was admitted at the hospital.
Okay. Show us.
Good after.
Lordship takes up page 40.
Paper book.
Paper.
কালকে কালকে 12টা বললে Dr. Subhasis Mukherjee. Yes, please tell me.
The cross-examination. The patient was brought by one HON'BLE brother-in-law, full stop. The history of injury as stated by the patient was accidental stove burn injury.
Where is the what is the admission memo?
The papers, those are the exhibit files, no?
Brother-in-law, that means doubt. Whether it is a statement of the patient or it is a statement of the.
It says patient.
This is at this stage we cannot. Asun. What is your submission?
It's a case of dying declaration. Your lordship has seen.
No, he is telling that at the time of admission, patient herself stated that. Why is that?
That cannot be the patient's version, Milord.
How can it not be the patient's version?
Because the patient's version has been recorded twice.
Okay, we shall hear the
once is
matter
the dying
very quickly.
declaration, second is the
by the magistrate. Learned trial judge has presumed guilt.
Has to be presumed. 32 is there, Milord.
There was no presumption of innocence, my lord. There was a presumption of guilt, contrary to everything that we have learned in criminal jurisprudence.
So you are ready with the appeal, I think.
My lord, your lordship was hearing appeal.
We shall hear the appeal
was hearing, in fact.
within very.
Lordship had fixed it today for hearing of the appeal.
No.
I was under the impression it was.
The learned counsel for the appellant has submitted that the learned trial judge has committed grave mistake by not relying upon the deposition of Dr. Subhasis Mukherjee, no?
Lordship.
Who has stated before the court that at the time of admission in the hospital, the patient herself stated that he suffered burning due to accidental stove burst. Stop. The learned trial judge has in fact relied upon the presumption of guilt, but not upon presumption of innocence as established practice in Indian judicial system. Stop. The learned counsel has relied upon several judicial decisions reported in AIR 2025 within bracket. No, AIR 2025 Supreme Court 1561 within bracket Namdirin Suresh versus State, 2004 CRILJ 1976 of Karnataka High Court within bracket legal state of Karnataka versus Sefi Ahmed, and also 2004 CRILJ 1976 of Karnataka High Court. Same.
Yeah, same. Copy দিয়েছে।
Oh, sorry. Stop. The learned counsel for the state, the learned counsel for the state opposes the prayer for bail. According to him, there are sufficient incriminating evidence, including the other, including the deposition of other independent witnesses, which show that the victim was set on fire by the present petitioner after pouring kerosene oil on her. Stop. Para. Stop. We have considered the above case law, above judicial decisions, and it appears that the present in the it appears that in the present case, the dying declaration was appeared to be done in compliance with all the parameters required under law. Stop. It also appears that similar statement of the victim has been recorded by the judicial magistrate under section 164 CRPC. Stop.
May I indicate what?
There are other evidences which corroborate the statement of the victim in this case. However, the case law reported in Suresh Supra shows that there was no corroboration of the dying declaration of the victim.
And there were inconsistencies
between
the dying declaration of the victim and another statement made by the victim.
Recorded under 164, another statement.
And there were inconsistencies between two separate statements made by the victim.
In view of the above, we are not inclined to allow the prayer for bail of the petitioner at this stage.
How long you are in custody, sir?
Only
2 years and 10 months.
Paragraph dismiss করে দাও করে paper book ready.
Lordship, may I seek indulgence, as there are various documents that I need to rely upon at the time of hearing.
Yes.
If Lordship passes a direction on the department because it has to be prepared by the department. So
Why you have not included in the paperwork?
I cannot do that, Lordship.
No, but paper book has been prepared.
Yes, but by the department. The
Yes.
department prepares it.
Certain documents are missing.
Critical documents, Lordship.
The exhibits are never part of the paper books.
No, yes.
It's never part of the, it's already there before your lordship.
Some exhibits are part of the paper book, some are not.
Do you have copies of those documents?
So,
What are those documents? How do we know?
I have a list of documents that are missing.
Very well.
I can provide that list to the department.
Since the paper book has been prepared, since paper book has been prepared by the department, we shall hear out the appeal. Stop. Learned advocate for the appellant says that the paper book does not include certain critical documents on which the appellant needs to rely. Stop. If learned advocate for the appellant supplies particulars of such documents to the department when will you give the particulars?
Within a week's time, Lordship.
Within a week from date, the department shall prepare a supplementary paper book incorporating such documents.
Provided it is exhibited, they relied upon. You cannot give your own new documents right now.
No, Lordship. From whatever is in the record from the TCR.
Provided such documents form part of the TCR.
Lordship.
Stop. Let such supplementary paper book be filed within 4 weeks from the date of the learned counsel for the appellant supplying the particulars of the documents to be included in the supplementary paper book. Paragraph lists the appeal under the appropriate heading fairly at the top. 5 weeks hence. 1 week for you to supply, 4 weeks for preparation, 5 weeks hence.
Can I point out one thing?
Yes.
So far as paper books in the criminal appeals are concerned, apart from death reference, those exhibits are never forms part of the paper book as per the appellate side rules and orders. If he has to obtain it, he has to apply for a certified copy. I have no issues with regard to your lordship.
Roy, I don't think Mr. Basu is asking for inclusion of the exhibits. Are you?
Yes.
Some exhibits.
Yes.
Oh.
He has to apply for certified copy.
Lordship, I cannot apply for a certified copy of trial court record.
Yes, you can. You will have to personally apply for that in the High Court. An advocate or your advocate on
those
record.
documents are within the record, then you can refer from the TCR during hearing.
It's a very critical appeal, Lordship, and I have to demonstrate that from the record, the learned trial court could not appreciate.
The records are here, Mr. Basu. You can always refer to the record.
Then we in case of getting certified copy, we have to send back the record to trial court.
His counterpart had got the copies. Without that, it could not have been exhibited. First. Secondly, as per our appellate side rules and orders, these are never included. We go through the record and argue the appeal. If he wants the copy, he has to apply for the certified copy. I don't mind in your lordship passing the order. But this cannot form a precedent. Yes, this will form a precedent.
From a prejudice to anyone.
This will form a precedent. This will burden the paper books, the department of the High Court.
You may have 1 or 2 cases, but we have
at least the liberty to apply for certified copy.
Yeah, definitely.
Not all ki bollam, not.
The advocate on record has to apply. Instead of the clerk, so far as the certified copy is concerned, the advocate has to apply.
We will provide this.
Department, High Court department. Only the advocate can apply for the certified copy of the law.
Certain. That the paper book does not include certain critical documents on which the appellant needs to rely. Stop. Such documents are exhibits, were exhibits before the learned trial court. Stop. The appellant will be at liberty to apply for certified copy of such exhibits in accordance with law. Tarpore, let the appeal be listed. Let the appeal be listed then 4 weeks hence? 4 weeks hence. fairly at the top.
11, 12. Correct. How many years?
No, 39.
Some imprisonment for 10 years and here's an incarceration over
Which one, who is your brother or sister? Without ascertaining the presence of you.
Sir, I'm praying for a short person. Short person.
সব এদিকে জুড়ে
40.
40, I appear for the appellant, my lord. Lord, the learned public prosecutor, Mr. Bitosok Banerjee and Mr. Arup Sarkar. 40. Monirul.
বিকাশক না বিতোষক
বুকুদা আছে।
বিকাশক or বিতোষক
Bitosok. Bitosok Banerjee. Post conviction, 5 years. My lord, there are 4 accused persons in the appeal. Now, appellant number 3 and 4 in the paper book, their sentence have been suspended by this honorable court. Now, my lord, the incident took place on 25th of September 2018. The incident was given a color like this, that 4 accused persons arrived at a club. 2 of them, those who have been granted bail, those whose sentence has been suspended, they stayed at the gate. These 2 petitioners, before your lordship, they went inside and Monirul stabbed the victim. Now there are 4 eyewitnesses, so-called eyewitnesses in the instant case. PW 1, 2, 3 and 6. Now their version with regard to the incident and shifting of the dead body to the hospital vary from each other, which gives a clear impression that they were not at all present at the place of occurrence. And my lord, this is one. Huh? No.
they are granted bail because your client stabbed him.
No.
That is the ground.
Yes. That is the version in the first information report. This first information report was preceded by the inquest. And in the inquest, the near relations signed. The investigating officer in his cross-examination specifically says that since after the incident, till the inquest and till the lodging of the FIR, just prior to the lodging of the FIR, the names of the assailants were not divulged by the near relations of the deceased. Whereas PW1, the wife, PW2 and 3, the brothers, claims themselves to be the eyewitnesses. This is the clear evidence of the investigating officer. Now, another aspect.
Mr. Sengupta,
my lord.
By the order dated 4th January 2022, a coordinate bench granted bail to 3 and 4.
3 and 4. We did not move, my lord.
You did not move?
No. Lordship, may kindly take up the record, my lord. Cran 1 was by Udirul and Jenarul. Cran 2 was by one of us, Bodur. One of us. And now for this cran, Bodur is the second application, Monirul first application.
Kindly goes through that order.
We've gone through the
There
order.
has been a total distinction so far as the other appellants are.
Yes.
There is.
The 1 and 2, who played an active role in holding the victim and stabbing him.
My lord,
So
we did not move.
Was rejected.
My lord, lordship may kindly come then, my lord. I'll have to take your lordship through the evidence, my lord. Lordship may kindly allows me because the eyewitnesses contradicts each other.
For hearing.
How many appeals can be heard altogether simultaneously?
My lord, 5 years in custody.
What does Kashmira Singh say?
My lord, there has to be at least, so far as the backlog is concerned, 10 to 15 division benches for hearing.
Correct. Correct. 5 years after conviction, they are there.
2 years, 11
There
months,
has been a
to be
distinction by
precise.
this High Court. There has been a distinction so far as the others are concerned by this honorable court.
But they had not applied, and that was in 2022.
22.
22. Mr. Roy.
Why is that?
January 22.
I've seen that.
So almost 4 years have gone by. So we are not on merits.
18 থেকে 22 কি বেলে ছিল?
No, no. 18 hai. Huh. During the trial, they were on bail.
On bail.
On bail.
Then we'll grant the bail. Trial বেলে ছিল 4-5 বছর হয়ে গেছে।
এই তো এখানটায়
অ্যাপ্লাই করেনি, ওদের অ্যাপ্লিকেশন করবে।
এই তো এখানে মার্ক করে রেখেছি।
এটা যেটা করেছে জাস্ট ডিস্টিংগুইশ করলো যে 1-2
Applicants number 3 and applicant number 1.
Convicts are on bail, their bail bonds are cancelled. They were on bail.
Application to was 3 and 4. Issue.
I have video call.
This is an application for suspension of sentence and grant of bail in an appeal filed by the appellants against filed by the petitioners.
I beg your lordships to interrupt once, beg your lordship's pardon. Bodor second application, Monirul first application.
Bodor?
Well, for the appellant petitioner number 2, he is moving for the second time. 1 is the first application.
When was his application dismissed?
My lord,
same day.
Same day, 20.
And other accused persons against a judgment and order dated December 17, 2020, passed by the learned additional district and sessions judge, first FTC, Lalbagh, Murshidabad, in SL number 48 of 2019.
Can you see the order? I'm not sure when the date.
Monirul, no. This was for Bodor. This is the nomenclature of the appeal. Bodor moved it.
I don't know, my lord. Your lordship will see Justice Bagchi and Justice Gorang Khan. Very recent.
No.
Where is that order?
But here it is recorded in the paper book.
If your lordship sees the orders.
1st of November 2019. 2019, Justice Khan was not here.
2019, the appeal also was
not here. If your lordship takes up the Grant 2 was affirmed on 24th of August 2022. Grant 2. So the rejection will be after that.
Yes.
Grant 2 was affirmed on 24th of August. Did your lordship get it, my lord? So, my lord, it's 22. And in the order sheet, while rejecting the bail application for Bodor, the date is inadvertently recorded as 2019.
Very well.
The High Court order, it is not annexed. High Court order,
High Court filed. High Court.
High Court order? Which order?
This Bodor's prayer for rejection.
Give it. Find it.
Oh, acha.
Do you have a copy of Kashmir Singh with you?
Not like
1977. ঠিক করে
এখন কি করবো বলো?
Yes. 1977.
In 2024, it is the department says 2 persons are on bail, 2 are in jail. But this is the order passed by recorded as 2009. Must be of somewhere of 2024. No. Must be sometime in 2024 because the preceding order is of 2024.
1977, 4 SCC. 1974, 4 SCC, 291.
গৌরাঙ্কান্ত এই সময় ছিলই
97,
This cannot be of
1977.
It cannot be of 19, of course. More likely to be of 22.
24.
Why do you say
The
so?
preceding order, your lordship sees, and there is a note by the department that 2-3 pages after that order, by that 2 are on bail, 2 are in custody. There is a note of the department. 2-3 pages thereafter.
2 persons were granted bail on 24th of January.
There is a report of the department, handwritten report. Can I find it out for your lordship? 2-3 pages after the order.
After the order?
Lord. Just 2-3 pages.
Oh, yes.
This is of 24.
Yes. So it records 2 are in jail, 2 are on bail.
Lordship. So this order must have been passed sometime in 2024.
Why? Why couldn't it have been passed in 22?
No, because my lord, 2 persons were granted bail in January 20. No, January 22.
22.
January 22.
Yes.
Then in
then
the later part of 2022, perhaps,
That's
because
right.
Bodor's crime is affirmed in August 2022. Yes.
Subject to correction. Who were granted bail
in January 22.
January 22.
Now, your lordship sees the report of the department.
In January 24, department says 2 are in jail, 2 are on bail. How is this inconsistent with Badar applying for bail sometime later in 2022 and his bail application being rejected?
No, perhaps in
August 22, he affirmed the bail application.
the order sheets. Thereafter, your lordship sees it is coming chronologically.
No. Oh, you are relying on that.
Yes.
Please don't.
Perhaps Justice Kant was.
Our files are.
And perhaps Justice Kant was not there in 22. If I am not
22.
correct.
22 ছিল না কোভিড এর আগে ছিল না
কোভিড এর আগে ছিল
সরি কোভিড এর পর 22 তে ছিল জাস্টিস কান্ত
Yes, 22 Justice Kant was here. Yes. So nothing can be definitely said.
Judgment date is 2020.
You will know. Well, this is this sentence for life sentence.
Yes.
Life.
Because it was rejected, nobody got it corrected.
By the said judgment and order, the four accused persons were convicted and sentenced to suffer life imprisonment. Paragraph. 2 of the accused persons, being the appellant numbers 3 and 4, were granted bail upon
4th of January 2022.
suspension of their sentence by an order dated January 4th, 2022, passed by a coordinate bench in Cran 1 of 2021. Stop. It further appears that a previous application for suspension of sentence filed by the appellant number 2.
Bodor Sheikh.
Being Cran 2.
Cran 2.
Cran 2 of 2022 was also rejected by a coordinate bench. Stop. The date of that order is obviously erroneously printed as November 21, 2019, when the appeal had not even been filed. Stop. Be that as it may, paragraph kore. Be that as it may, we see that the present petitioners,
Both appellants 1 and 2 are before us.
Yes, Monirul and Badal
Present
Sheikh.
petitioners, being the first and second appellants, are in custody for more than 5 years, for about 5 years.
4 years, 11 months after the
For about 5 years, post their conviction. Stop. It is anybody's guess as to when the appeal will be heard. Stop. There are numerous appeals pending which were filed prior in point of time. Stop. Further, comma, we are told that the petitioners, along with the other accused persons, were on bail.
Yes, my lord.
During trial. Stop. It is not the paragraph. Learned public prosecutor, comma, to our query, comma, tells us that there is no complaint that the petitioners, comma, while on bail during trial, comma, jumped any condition of bail or misused the privilege of bail in any manner. Stop. Paragraph. Since we cannot say with any certainty as to when the appeal will be heard, and since we find that the petitioners were on bail throughout the trial without misusing the privilege of bail, comma, without touching the merits of the case, and keeping in mind the principle of law laid down in the case of Kashmira Singh bole purota diye debe, comma, we allow this application. Accordingly,
leave district Murshidabad and shall meet the IC once. And you can be represented as and when called for the
this is CRAN 3.
CRAN 3.
Why is CRAN 2 also listed? Erroneously.
Well, this will be
Who was that Bodor?
To the satisfaction of learned ACJM Lalbagh.
No, the learned CJ Murshidabad. Don't invent something. CJ Murshidabad.
The trial court is Lalbagh.
Oh.
Whatever it is.
যদি দুপক্ষ চলে এসছেন তাহলে বলবেন জজ সাহেবকে, তখন ডাকবো। বললেই ডাকুন। আজকে কোনটা এটা কত নম্বর? অনেকগুলো 500 রয়েছে, আপনি কোন
my lord, the past over matters, my lord, might be.
যখন তখন মেনশন করতে পারে কেউ? পারে না।
Hey. 41. Item 41.
Lordship, in this matter, I am appearing for the appellants. This is my second application under.
Who is for the state?
I am not aware who is appearing for.
Have you served? Have you served on the state?
Lordship, in this matter, I am appearing for the first time. I am not aware if service has been made.
Are you appearing in this matter? Yes, that's fine. He doesn't even know whether he has served the state.
We are appearing. He has served, man.
Yes. Yes, tell us.
Lordship, this is my second application under section 431 of the Bharatiya Nagrik Suraksha Sanhita, challenging the order of the learned
Yes.
challenging the order of the learned special judge POCSO court passed on 11/11/2021.
What is the age of the victim? Why is it? Have you served upon the victim?
ওটাও তো বটে। আরে
It is law, sir. You have to serve the de facto complaint or the victim before moving any bail application. So have you served?
What is your name?
But he doesn't know he's appearing for the first time.
This is your first appearance as an advocate. When were you enrolled?
Lordship, in the month of November 2025.
25.
Lordship.
Please help me. Why don't you serve? You effect service.
In a POCSO case, victim is required to be served for moving any bail application. Okay. He will assist only on this point.
This is an application for suspension of sentence and grant of bail in an appeal filed by the petitioner against an order of conviction for commission of offence under section 6 of the POCSO Code, where the petitioner was sentenced to suffer 20 years, suffer rigorous imprisonment for 20 years.
So your special leave petition was refused.
Lordship. Lordship,
But,
we have
giving liberty to appear before
Lordship
us.
for the second time.
State will intimate the victim.
Paragraph, let the state effect service of this application on the victim girl and file service report on the next date. When?
At least 1 week.
1 week. করে দাও বুধবার, paragraph list the matter. Come back next Wednesday.
Obliged.
You are the advocate on record also.
No advocate on record was asked by advocate.
Yes, come on. Item 34 cram.
Yes.
The tour and
Yes, the CRAN 34.
Deep
Kunal.
(32 to 36).
My lord, in this matter, my lord, 19 persons were placed on trial. My lord, the charges were of common object. My lord, 307, 354B, 325, 302, and my lord, 506. All the 19 accused persons were acquitted of all the charges except 302, and instead of my lord, the common object part, 34 was substituted at the time of my lord, convicting the appellants. My lord. Only 5 persons were convicted. 14 were acquitted in the my lord, from the same evidence. My lord. 14 were acquitted of all the charges. 5 were convicted under 302, 34, acquitting them also from rest of the sections, my lord. So, my lord, the 325 and, my lord, 307 charges were, so far as in respect of injured eyewitnesses, my lord, that was also disbelieved by the learned trial judge, because 305, 325 and 307, there was acquittal. So, my lord, the injured eyewitnesses definitely could not have suffered injuries. That is why they were acquitted, my lord. Now, my lord,
but all the witnesses have named 5 witnesses.
my lord,
I have gone through the deposition.
I will show to your lordship now. Now, my lord, kindly comes to, my lord, whether, my lord, I have already handed over the copy of evidence on the last occasion.
Yes, that's why I have read.
Yes, my lord.
Thank
My
you.
lord, now kindly comes to, my lord, my lord, evidence of investigating officer 1, so, my lord, PW 10.
Page number.
Yes, my lord. My lord, PW 10 is at, it starts from page 39 of the compilation.
Yes.
My lord, kindly comes to the relevant page at page 44, the internal page 6 of PW 10. Page 44. Your lordship has got it? Now, my lord, 4th paragraph. In the FIR,
Yes.
it starts with, in the FIR, there is no specific allegation as to who assaulted the deceased, and the allegation is general in nature. Your lordship has got it? Now, my lord, 3 paragraphs thereafter, during interrogation, Muhammad Mofijuddin did not state before me the specific role played by the accused, such and such, all these 5 accused persons. So, my lord, in the FIR, no specific role attributed. In the 161 statement also, no specific role attributed.
Who is the de facto complainant?
He is the de facto complainant. So, my lord, initially, no specific role was attributed. This was, my lord, developed at the time of trial only. My lord. Now, my lord, another thing, my lord, kindly comes to page 43 once. My lord, another cross-examination part of the investigating officer. My lord,
No, whether this point was dealt with by the learned judge.
my lord, this was evaded. Nothing was stated.
It was evaded.
Evaded. Now, my lord,
very-
no specifically.
It's a very vital point
My lord,
you have
no,
raised.
definitely, my lord. Now, my lord, another one thing, my lord. Page 43, about 5 paragraphs from top. My lord, on 8, it starts with on 18/6/21.
43,
Page
number?
43, internal page 5.
Yes.
It starts with 18/6/21. The paragraph, about 5 paragraphs from top. Your lordship has got it, my lord?
Yes.
She is one of the so-called claimed eyewitness. I examined Mumtaz Khatun. She is one of the aunt of the accused. At PS or 8:30 in her statement, Mumtaz Khatun did not state to me as to who assaulted Sultan. She also did not say to me who outraged. No, that the separate part is different. So, my lord, these, first of all, my lord, kindly considers the date 18/6/21. My lord, the incident occurred on 19/5/21. These important eyewitness was for the first time examined 21 days thereafter. Even after 21 days, no name, my lord, so far as specific allegation is concerned. No name of the eyewitness.
How long you are in custody?
My lord, I am in custody for 4.5 years. And, my lord, yes.
Conviction is of 24 August.
Yes, my lord.
25.
Yes, my lord. The appeal is of 1 year. My lord, I am in custody for 4 years, 7 months. Now, my lord.
You're on bail or in custody trial?
No, custody trial. Now, my lord, kindly consider.
Only 19 or.
No. Rest of the on bail, this convicted person is in custody.
Yes.
This convicted person already in custody.
I have certain questions. We are preparing questions for you. Don't worry.
Now, my lord, the next part, your lordship will kindly consider one thing. My lord, it has happened in an open field in daytime. All the eyewitnesses, my lord, in fact, the prosecution witnesses have admitted, the investigating officer have admitted, all the eyewitnesses are from the same family. Open field, my lord, it is not a case that it has happened in a house. Then only, my lord, eyewitnesses. My lord, in an open field it has happened. Not a single eyewitness. Though, my lord, the investigating officer, the prosecution witnesses have stated there were other persons in their evidence. So presence of other persons were there. Not a single independent eyewitness. All from the same family. Same family. Now, my lord, another thing, your lordship will see, my lord, from the evidence of autopsy surgeon, your lordship will see it is at page, my lord, PW 8. That is at, my lord, page 31. Oh, no, it's a PW, my lord, page 35. My lord, the page 35, your lordship will see about 2 paragraphs from the bottom. Opinion as to cause of death was to the effects of head injury as noted in PM report, antemortem unit. Your lordship has got it, my lord?
Yes.
Now, my lord, the next evidence, the doctor who examined the deceased. That is PW, my lord, 9. My lord, kindly comes to page 38, the cross. Your lordship will get in the injury report of Sheikh Sultan Ali, that deceased, it has been mentioned there is a cut injury over the head. A cut injury. Your lordship will kindly consider that. Now, my lord, kindly comes to the evidence of PW 7, the one of the eyewitness, the aunt of the accused, aunt of the deceased, page 31. My lord, the 1 paragraph from bottom, page 31. Your lordship has got it? 1 paragraph from bottom.
31.
31, 31. PW 7, the aunt of the deceased, who is also an eyewitness. My lord, 1 paragraph from bottom. Accused Mujibur assaulted Sheikh Sultan on his head by a bamboo tara, causing severe bleeding injury.
So
the fatal blow is only so far as Mujibur is concerned. All other assaulted, that is the version of the eyewitness, though that is non-believable because there is no other independent eyewitness. So, my lord, fatal blow by Mujibur.
Case of injury is same. Head.
Head.
Every witness is saying that.
But the specific overt act is against Mujibur.
Yes, yes.
My lord, your lordship has seen this, my lord. Now, my lord, I will show other eyewitnesses also. My lord, kindly comes to page 26 once, my lord. PW 6, she is also.
Page 26 of what?
My lord, the compilation, my lord. The PW 6.
PW 6.
He is one of the uncle of the deceased.
Yes.
Your lordship, from the 5 lines from bottom. Specific name? Mujibur assaulted Sheikh Sultan on head by a bamboo tara.
Yes.
So, my lord, even if we consider for argument's sake that all were assaulting, the fatal blow was given by Mujibur only, not me.
Was granted bail.
No. Mujibur is also a convict, but I am not for Mujibur. I am for Nojrul.
Only one.
Only one.
Nojrul.
Nojrul. Now, my lord.
The Nojrul names is not there.
Nojrul, it is stated that Nojrul also assaulted, but not on the head specifically. The specific allegation of head injury, which is evident from the autopsy surgeon as well as the doctor who examined, that head injury is the cause of death. That is only against Mujibur. Specific. Not against the rest of the 4. Now, my lord, kindly comes to the evidence of.
Almost arguing the appeal. Let us.
My lord, I have a good case. I can only show that whether I have an arguable case or not. If it is an arguable case, my lord, I can pray for suspension of sentence. That is only the case, my lord.
My lord, kindly consider PW 2, 3, 4, all are eyewitness. Specific allegation, these persons also assaulted on the head.
PW 2.
2. My lord, kindly first come PW 2. 6 Thabed Ali, my lord, 5 line, my lord, bottom in the paragraph, thereafter, versus got it.
Now, why his name does not transfer in the FIR?
No,
I want to know why his name does not transfer in the FIR.
His name is there.
Name is there.
Yes.
25 names are there.
All was there.
All.
All
No
name was
specific
there.
allegation.
Yes, specific allegation PW 2, 3.
No,
all
I have the FIR.
Yes. Well, kindly see the PW 2.
You have said that.
My lord, kindly see the FIR.
Defect complaint is come thereafter, my lord.
So there are sufficient materials against.
No, my lord, kindly see the FIR. I have the FIR.
Yes. So
the FIR only states one sentence. About 20-25% attacked suddenly surrounding with their weapons. 20-25%. 14 were acquitted.
Yes.
And my lord, there is a long
According to
standing.
him, only head injury is a fatal blow.
By
So
which
only
person?
Mujibur.
No. Can you see PW2, my lord, first? PW2 page 8, my lord. Compilation 8. My lord, from in the bottom, my lord, there after sect Mujibar. My lord, can you find out, my lord?
Where?
My lord, 1, 2, 3, 4, 5. My lord, 5, my lord, 5 paragraph from the bottom, my lord. Thereafter, Syed Mujibar. My lord, name Sheikh Sirajul, Sheikh Ghaffar, Ghulam Mustafa, and Syed Najul assaulted on head. But the next sentence, your lordship will see. All over body of the Sultan by bamboo, iron rod, and sabal. Same witness. Iron rod, shabal, nothing, my lord. Nothing was, my lord, recovered, my lord. Same witness also PW. My lord, I have an arguable case, my lord. Iron rod, shabal, not, my lord, recovered. Only recovered is bamboo tara. That is also 2 days thereafter, which was handed over by the complainant himself.
The learned counsel for the applicant has submitted that the petitioner Nojrul has been falsely implicated in this case since there is no independent eyewitness in support of the prosecution case. Furthermore, the evidences of the witnesses show that fatal injury was inflicted on the head of the victim and only one accused, namely Sheikh Mujibur, had done it.
And no names were there initially. Sure. All were there, omnibus allegations.
The FIR contains omnibus allegation against 25 accused persons, including the present one. Stop. He has further argued that out of 25 accused in the FIR, 19 accused have been acquitted by the learned trial judge. Stop. The independent eyewitnesses are relatives of the deceased, and they have developed their version during trial. Stop.
And I'm in custody for 4 years, 7 months.
The learned counsel has also pointed out that the petitioner is in the custody for about 4 years, more than 4 years. It appears the learned counsel for the de facto complainant has raised strong objection. According to him, all the eyewitnesses have alleged that the present petitioner was present and acted and took part in assaulting the victim. Stop. Accordingly, he opposes the prayer for bail. What is your submission, madam? The learned counsel for the state has also opposed the prayer for bail. According to her, there are sufficient incriminating materials against the present petitioner, along with 4 others. Stop. It appears on the record that the judicial decision of Saudan Singh does not appear in this case, since after conviction, the present petitioner is in custody for 1 year, 6 months.
4 years, my lord. I am
after conviction.
No. After conviction, my lord. For Kashmira Singh is there, my lord.
Stop.
Kashmira Singh is there. My lord, I have. I have made out
the eyewitnesses
arguable case, my lord.
All the eyewitnesses have named the present petitioner as one of the assailants, and further, the FIR also contains the name of the present petitioner as one of the assailants. Stop. Considering all the materials on record and finding that there are some certain incriminating evidences against the present petitioner, we are not inclined to allow the prayer for bail petitioner at this stage. To be pressed and selected. Huh? No.
Paper book has been filed.
Yes.
After 1 year.
My lord,
For 1 year.
paper book is ready, my lord.
About
My lord, it may be hard out in some time, my lord. Not very recently because, my lord,
List the five.
I can.
List the five appeals.
An arguable case is there.
Yes, what now?
Under the appropriate heading, 2 weeks hence. এই শোনো একটা, এদিকে শোনো।
Great.
49 है ना? 49 तो
पाঠিয়ে দাও।
9 है ना? हाँ बोल।
করে নিয়ে আসবেন আর কি।
Pass over matter lordship 39.
39.
Yes, lordship.
Passover matter also, my lord, item number 20, which Trivedi Zerif can be taken.
29.
39.
39, sorry, 39.
The terms imprisonment lordship 10 years. I am in incarceration for about 5 years. And earlier bail was rejected in the year 2021.
39.
And in this, I am on bail during the trial. And
What NDP is? What is it? POXO?
304B.
498 is
304.
4B.
Mother-in-law
You are
already
for?
granted bail by this honorable court and suspension of sentence, my lord, against the
Husband.
mother-in-law already there.
Almost half the term
Lord,
he
what's
has.
My lord.
When was it rejected? Last?
In the year 21.
Where is it?
Annex the order lordship
Yes.
at page number
Issue.
18. At page 18, lordship.
The petitioner renews.
My lord, one indulgence, my lord. The CRAN copy served upon us is CRAN 1, my learned friend sir. But in the cause list, my lord, it has been mentioned that CRAN 3.
It is CRAN 3.
3, lordship.
But they have
By mistake. By mistake.
My lord.
It's 3.
CRAN 3. The petitioner renews his prayer for bail for suspension of sentence. For suspension of sentence and grant of bail, which was earlier rejected by a coordinate bench by an order dated November 23, 2021, passed in CRA 21, passed in CRAN 2 of 2020. Stop. Paragraph. The petitioner was convicted of offences punishable under sections 498 capital A oblique 304 IPC and was sentenced to suffer rigorous imprisonment for 10 years. Stop. The petitioner says that he has already served close to 5 years. Stop. Further, comma, he was throughout on bail during the trial. Stop. There is no certainty as to when the appeal will be heard. Stop. Hence, he should be granted bail pending disposal of the appeal. Paragraph. Learned state advocate, while opposing the prayer, comma, in his usual fairness, points out that there were 2 convicts.
Yes.
Mother-in-law.
Mother-in-law has already been on bail.
Suspended. That the sentence of the co-accused and the other convict, being the mother-in-law of the victim lady, has already been granted bail upon suspension of sentence. Stop. He also does not dispute that the petitioner is in custody after his conviction for close to 5 years. Stop. Paragraph.
We therefore see that the petitioner has served out almost half of the sentence of 10 years. Stop. Further, comma, it is nobody's case that he jumped any condition of bail or misused the privilege of bail when he was on bail during trial. Stop. Paragraph. Considering the overall facts and circumstances of the case and seeing that there is no certainty of an early hearing of the appeal, comma, keeping in mind the ratio of the case, ratio of the decision in Kashmira Singh, we allow this application.
Loss. 498 304B 34.
304 capital B oblique 34 করে দিও।
Deeply applied.
Not leave melody item number 28. Trivedi and the Bhattacharya here, melody.
চলো। Mr. Bhattacharya, once it is passed over, very difficult. You have to appreciate the burden that is on us. Suddenly, these juniors come and mention.
Kindly takes it up. Kindly takes it up tomorrow. There's no problem. Kindly takes it up. Kindly takes it. No issues.
And unqualified.
No. Unintentional. It is below. No. I was also held extremely.
You were both held up.
Kindly part.
No problem.
Item 42. Six. 46.
Case 46.
My lord, I'm led by Mr. Probir Mitra. He was here. He is on his legs before court 20.
এটার আগের গুলো কি হলো 46 এর আগের গুলো
My lord, date করা।
Oh, date করা। Yes.
42 টা কি হয়ে গেল
42 কেউ
এলো না ও আচ্ছা 46 yes
Sir, Mr. Probir Mitra was here, but he's on his legs before court 26. If you kindly allow a short pass over.
Passover 46 Passover next
49.
কালকে
yes
Yes, may I be accepted under the appellant?
date
49.
on the prayer made on behalf of the state comma let this matter stand adjourned for the day
Fifty.
My lord, I appear for the appeal. No, my lord, the appellant is the husband. No, my lord, the case was initial. Suspension of sentence in portion.
এই রিপোর্ট 10টা পাঠাতে পারবে
The appellant is the husband. Well, he is convicted under sections 498 oblique 302 IPC. Well, at 498 2 years, 302 for life. Now, the proceeding was started in the year 2002. Well, the judgment and order of conviction and sentence came in 2024. But I was all along on bail, my lord, in courts of trial. Now, my lord, the prosecution case is based on 2 dying declarations. Now, my lord, the first dying declaration, my lord, was made by the victim lady on the date of the incident. Now, my lord, she was initially taken to the Modhomgram Rural Hospital.
How she died?
My lord, she died by sustaining a burn injury.
Now, my lord, on the date of the incident, my lord, she gave her first dying declaration.
I just found that mother-in-law never sustained birth.
No, only husband. Husband is the sole accused.
Only the wife.
He's the only husband.
My lord, sole accused.
You said only husband.
Now, my lord, what had happened here was before the Muddongram Rural Hospital, she made a dying declaration that she was cooking. My lord, the stove had burst and she caught fire. Now, my lord, 10 days.
Who took her to there?
My lord, she was taken there by PW4. My lord, he is the neighbor.
The neighbor.
The neighbor, my lord, took her to the hospital. My lord, the neighbor says that before the neighbor, she had stated that the stove had burst and she had caught fire. Kindly comes to the evidence of PW.
Stove has been
No, the investigating.
I want to know.
No,
my lord. Pressing this matter.
No, my lord, why I say this, a seized witness in his evidence says that the stove was lying in the PO, the investigating officer did not seize it. Kindly comes to the evidence of the seized witness. Now, my lord, kindly, my lord, he is PW7 Labonnamoy. Labonnamoy in his evidence, he says that from him, a jerrycan was seized, but Labonnamoy had stated that I had seen a bus stove in the PO. I had asked the investigating.
In the dying declaration, what she said?
My lord, in the first dying declaration, she said stove burst.
That is not dying declaration before the.
But after 9 days, another dying declaration was recorded in which she said that her husband has poured kerosene and set her on fire.
50-50.
Now, my lord, kindly comes to the evidence.
All along we are on bail.
All along on bail.
And you have said that if I convict, then you will take me.
No, my lord, kindly comes to the evidence of one witness. The investigating officer, my lord, the investigating officer said that no, I did not collect the bedhead ticket from Muddongram Rural Hospital. We adduced it as a defense witness. We called upon the doctor. The doctor said that yes, this is my statement. This is my signature in which the statement was recorded, and she had indeed died of a stove burst injury. My lord, kindly comes to one evidence, my lord, which is the evidence of PW7, my lord, page 101. My lord, Labonnamoy is a seized witness.
When the conviction was, order was passed?
My lord, August 2024. I am in custody for 1 year and 3 months now. The case is of 2002. Kindly comes to the evidence of my lord 101. Kindly comes to the cross-examination. I went to Muddongram Rural Hospital where Geeta Mukherjee was taken there with burn injury. Khushi Mondal and Raju Mondal were present at the hospital. Geeta Mukherjee in the hospital in presence of all told that a stove was burst and she was caught fire. Doctor recorded a statement. I cannot recollect whether Geeta Mukherjee was taken by the executing bond from Muddongram Rural Hospital to Arjikor. I along with my wife went to Arjikor. Khushi Mondal told to Geeta Mondal at Arjikor to say to the doctor.
So this is according to it is a stove burst. What is your submission, madam?
Should I be honest before your lordship?
Yeah.
Should I be honest before your
So
lordship?
you must be honest always. Always.
All the witnesses ought to have been declared hostile. They have deposed in favor of the defense. They were not declared hostile. So it goes in favor of the defense. They have there is a dying declaration, which is the second version of the patient. So far as the initial hospital, which is Muddongram, the documents were not seized by the investigating agency. So far as the second dying declaration implicating the present petitioner is concerned, my lord, it is categorically stated in all the cross-examination that 2 witnesses have tutored the deceased to
make that
statement.
Which statement?
The second statement of the appellant setting her ablaze. That has also come in the evidence, but these witnesses have not been declared hostile.
So we have to grant bail. Learned counsel for the.
This is an application for suspension of sentence and grant of bail in an appeal filed by the petitioner against the judgment and order dated.
Well, it's judgment and order dated 22nd August 2024 and 23rd August 2024.
August 22/23, 2024, passed by
My lord, the learned additional sessions judge, 5th fast track court, Barashat.
In
My lord, in sessions trial number 1/8 of 2006.
stop by the said judgment and order, comma, the petitioner was convicted under sections 498A and 302 of the IPC and was sentenced to suffer rigorous imprisonment for life. Rigorously imprisonment for life. Stop. Paragraph. The petitioner says that there are innumerable loopholes in the prosecution case. Stop. The prosecution witnesses have recorded inconsistent evidence. Stop. He was throughout on bail during the trial between 2002 and 2024. Stop. He has a highly arguable case for acquittal. Stop. He is already in custody post-conviction for about 1 year, 3 months. Stop. He prays for suspension of sentence. Paragraph. Opposing the prayer, comma, learned state advocate points out that there are sufficient material to support the conviction, sufficient evidence to support the conviction, support the order of conviction. Stop. The appeal, paper book is ready. Oh, the appeal may be heard out on an early date. Stop. The petitioner's prayer should not be granted. Paragraph. We have considered the facts and circumstances of the case and the evidence on record. Stop. Prima facie, comma. There are inconsistencies in the evidence recorded by the various prosecution witnesses. Stop. There also appears to be 2 statements of the victim lady which are inconsistent. Stop. In one, she says that she suffered a fire injury due to a stove burst. Stop. We also see, paragraph 8, we also see that the petitioner was throughout on bail during trial. Stop. It is nobody's case that the petitioner jumped any condition of bail or misused the privilege of bail. Stop. Paragraph. Considering that the petitioner has a prima facie arguable case and that he never misused the privilege of bail during trial, and also keeping in mind that there is very little possibility of early hearing of the appeal, since paper book is not even ready, we are inclined to allow this application.
What is the address?
My lord, this appellant, my lord, stays in Barashat. My lord, his police station is Barashat.
We'll meet once in a month. Just have to the usual condition.
Great. 12:45.
Okay.
12:45 fixed matter, item number 38.
He's the applicant.
My lord, I am appearing on behalf of the appellant. My lord, I am led by Mr. Chakraborty. Mr. Chakraborty has already concluded his arguments. Today, my lord, the respondents will use.
You will keep us. Can we release other matters till recess? Till recess. That's tomorrow. 2 to 3. Today 2 to 3. এই দুটোর সময় ফিক্স আছে নাকি আজকে কিছু anyway
May I proceed?
Lord, yesterday we confined to our case, defense case, only whether section 50 applies here or not. If applied, then whether there is any violation of section 50 or not. These are the two aspects that has been heard by my learned.
First one is section 50.
First of all, whether
body search,
whether the evidence attracts applicability of section 50 or not. Number one. Number two, if attracts, according to your lordship, then how far is the violation? Now, section 50,
You said that this voluntarily he took out the things and handed.
now, in order to buttress my case, I would beseech your lordship to only consider two evidence, not more than that. PW1 and PW4. If your lordship kindly take trouble to turn to page 18. Page 17 is the start of evidence of PW1.
18 of
page 17 of the paper book.
A paper book. Though. আমাকে দিন না
But I am not troubling your lordship by reading page 17. It's not necessary. Kindly turn to page 18. Please turn over. Page 18, second paragraph. It's a relevant portion.
Just tell me.
May I start? Said team was led by Sri Shantun White. He is PW4, the superintendent of NCB, KGU, and he was the gazetted officer. And we left office at 12 hours, reached city center. It's a public place. My lord, kindly take note, city center, a public place. Thereafter, surveillance was mounted, and about 3 hours, a taxi stopped in front of city center 2 in the bylane, and a person got down from the taxi who has a Nigerian look. At that time, total 3 officers, 2 constables, totaling 5 persons were in the raiding team. Thereafter, we reached near the said person and asked him of his nationality. The said person replied that he was a Nigerian and introduced himself as James Kelvin Elward by showing his passport. Thereafter, we introduced ourselves by showing our official identity and 2 independent witnesses who were with us, namely Ratan Mondol, Shubham Das. Unfortunately, these 2 were not examined.
Why?
That only prosecution did not produce them as witness. I can't go beyond evidence. What is there? What is that is there?
These are serious.
2 witnesses, independent. They signed on the scissor list, but were not examined.
Whether summons were issued or not. Summons were issued upon them, but they did not appear. This type of allegation is there. Or
if now this aspect, since this is fallen up from your lordship, this aspect I would address only one thing. If evidence of NCB officers convince your lordship, then your lordship cannot look into whether independent witness was examined or not. If their evidence is not convincing, then your lordship definitely can look into this lacuna, why they were not examined. They were present. Their signature were not disputed. Scissor list was exhibited.
But there are judicial decisions that there should be some explanation why this type of independent witnesses are not produced. That's why I'm asking whether
definitely.
It is a duty of the prosecution to issue summons upon the witnesses through court, whatever it may be. Now, tell me.
Thereafter, we intimated him with the input available with us and introduced to search him.
Intended to search him.
Intended to search him, and then we gave him notice under section 50 and explained him about the provisions of the said act. Thereafter, he was told that if he wished, he could be searched in presence of magistrate or gazetted officer as provided section 42 of the act. He was also informed that one gazetted officer was already in the raiding team.
Why this was informed that one gazetted officer was already in the raiding team? So giving a chance that he should be, that is we are consulting.
I can't answer this. I must be candid to your lordship. I cannot answer this. What is there in the evidence? I have to place it.
Yes, tell me.
He was further told that he could search the NCB team as well as independent witness, but he declined. Now that he declined, your lordship has already seen from the exhibit 3. Exhibit 3 is very categorical. This is copy of said section 50, that is exhibit 3. Thereafter, my lord, page 19, second para. Thereafter, the accused voluntarily handed over 2 plastic pouches to me, one of which was filled with black color such and such. During scrutiny of said pouch, 45 grams and 125 grams. Now, second and third para, my lord, I am emphasizing on these 2 paragraphs. Drug kit says it's cocaine. These are not disputed. This is admitted. Now, my question before your lordship would be, does these 2 paragraphs constitute personal search? If your lordship feel that yes, this is personal search, then, my lord, the argument of appellant would get some credence. If your lordship feel no, this cannot come within the ambit of personal search, then section 50 has no application here. Section 50 is strictly confined to personal search, not anything else. I'm giving a judgment. I will rely on that judgment where Supreme Court in 2023, paragraph 64 gives us a guideline of section 650 and very categorically said, that is why I argued on the last occasion yesterday that Ishait Sheikh, that has been relied on by the appellant, cannot be give any credence.
Chief Justice Chandrachud, no?
No, it's Justice Pardiwala written. Paragraph 64 gives a guideline of section 50. Relied on several judgments, including Rajinder Singh and Balveer Singh of Constitutional Bench, 1999 Supreme Court, and gives up categorical guidelines. So now these 2 paragraphs of page 19, I just repeat for my satisfaction. If your lordship feel that voluntarily handed over contraband would constitute personal search, then my lord can definitely consider section 50, its applicability and its violation. But if your lordship feel, and my humble submission would be voluntarily handed over means there was no scope of personal search, then section 50 has no application.
So videography is required as a Sheikh Kalu or something.
My lord?
Videography of seizure process?
No, photograph was there. Photograph, section 52, there is no violation. I didn't find any violation. There was no videography.
At the time of seizure,
and that question was not even suggested. I'm shocked to see cross-examination.
No, Mr. Bhattacharya, we are asking, isn't it mandatory now to videograph the process of...
Yes, definitely. Since 2017, 2018, there are series of judgments on videography. Series of judgments.
There must be.
Is there a videography of this seizure?
No. Nothing.
So mandate
photograph was there. That was exhibited properly, everything done. But there was no videography. And not even suggested by defense.
Yes. Then
now, may I trouble your lordship to skip to the cross-examination part? Cross-examination is at page 26.
Yes, cross-examination.
My lord, kindly see first line of cross-examination. I wrote the source information in the NCB form number 1 and submitted it to Zonal Director NCB KJU. This is admission compliance of section 42. Time 12:30, next paragraph, but in the relevant entry, movement registered, it is not specifically mentioned. We do not have any uniform, so we went red in simple dress. We did not reach local PS. No written notice was given to independent person. This is not at all mandatory. Now, page 26, 1, 2, 3, 4, 5, 6 para from the bottom. It starts with, we did not issue any written requisition to any executive magistrate or GO of any other department. We did not take accused to any magistrate for such, since PW4 was the gazetted officer, they did not bother. Not a fact, accused did not voluntarily agree to be searched. No application was moved for statement. 164, accused made confession during duress and coercion. In next page, there was Though airport is tightly secured place, possibility of anybody
So
come
you-
out cannot be ruled out. The search and seizure procedure continued from,
You admitted,
yes,
you admitted the accused made confession under duress and coercion.
that's what I placed. It was not placed by appellant. Appellate court's power is unlimited to scrutinize evidence, both facts and law.
Just a minute. It's a very vital thing.
I submitted, my lord. I have to place evidence on record. We can't change it.
PW1 is the complainant, in fact.
It should have been recorded, not a fact.
What a fact. But you cannot say that.
Definitely. In page 27, middle portion, it says search and seizure procedure continued from 3 hours to 5 hours. The sample seal was not submitted before the court. I took the seized alarms from PO to NCB office, deposited same. There is no mention in the complaint that seized article remained in my custody till his deposition in the NCB. I cannot say whether IO collected CCTV footage from the airport. We deposited seized article in the NCB go down. Now, this
Mr.
is
Bhattacharya, how to get over this?
how could I
No independent witness.
learned when a witness deposed, it's the duty cast upon the witness to see what kind of deposition has been recorded by learned judge. My Lord Justice Sinha has done on almost probably 500 trials in his judicial career. I spent almost 15 years in trial court. How could I get rid of this? Isn't it a duty of the witness to point out that, Madam, Your Honor, kindly take note that this is not a fact? This is a suggestion.
This was not pointed out to the trial judge.
It should have been pointed out,
Correction.
both by the lawyer as well as by the witness. How did he sign this document? Isn't it the duty of the witness to sign his deposition as to how it was recorded?
And he's
Whether it was recorded in verbatim or not?
He is the most important witness.
Now, my lord, kindly take trouble to PW4 at page 32. Now, page 33 is, I would beseech my lord to kindly consider, it starts with page 33, middle portion, subsequently. The paragraph starts with word subsequently. Subsequently, James Kevin Edward handed over the following items to Sri Manoj Mishra, who is PW1, and also showed his empty pocket. Does this evidence constitute section 50 of personal search? When it is voluntarily handed over, how could we feel that it would tantamount to personal search? My lord, CRPC dealt with search in section 100 and section 165. Nowhere it is said that personal search means physically it is search, but that's what we always presume, that a person to be searched by police under when he was arrested. He was not even arrested at that point of time. So what fallen from my Lord Justice Banerjee, that he was coerced or duress, my lord, can we say that he was arrested then coerced and duress? He was not even arrested at that point of time. Kindly peruse the arrest memo. Kindly see the date and time.
Yes,
so coercion and duress would come when he was arrested and then searched. We are not questioning seizure. We are questioning search. Can we say that he was personally searched? That is what troubling me here. We cannot say, in my humble submission, my lord, we cannot say that he was personally searched. So coercion and duress doesn't arise. Recording of evidence I cannot change. But yes, we can interpret. Can't we interpret in that manner? That is my question before my lords.
So the accused made confession under duress and something.
That is,
So
that would
is
come
there
under
any
section 67.
What is the confession? What is the, there is no confession at all.
Then
You can
then that cannot be, that cannot tantamount to confession, because he was only asked.
Section 50. PW5 has also said voluntarily handed over.
Exactly.
So Section 50 nahi.
52A?
I'm now, kindly allow me to place this judgment.
And 52A, there's
Judgment and you know, but the wala sahibe.
My lord, it's a, I have this bad habit of giving a short note. Section 50, resemblance of fruit of poisonous tree. It's a very famous quote of American Constitution. Now, Lordship, the judgment that is reported as Ranjan Kumar Chadha is 2023. My lord, kindly 2023, AIR 2023 5164. My lord, kindly take trouble to turn to para 64 at page 5190.
5190.
5190. On the left side, my lord would get the page number.
Yes.
Para 64. From the aforesaid discussion, the requirements envisaged by section 50 can be summarized as follows. Section 50 provides both a right as well as an obligation. The person about to be searched has the right to have his search conducted in the presence of gazetted officer or magistrate if he so desires. And it is the obligation of the police officer to inform such person of this
Mr.
right.
Bhattacharjee, we don't have much time. We'll read this. You have given it, we'll read this.
No,
My lord, only then, my lord, for my satisfaction, kindly see the last Roman 7.
Yes.
That is what I have tried to impress upon your lordship. Roman 7 is what it says. It mandates. That is why I said, my lord, yesterday, Ishat Sheikh is per inquirium.
Section 50 is actually only in case
Only personal search. There is no other option. If it is search from a gunny bag, no section. A person is carrying bag.
So there are earlier decisions also of the Supreme Court we have come across.
And what about section 52A?
Now, my lord, section 52A, lordship, if your lordship kindly take trouble to my written notes. Page 10. Page 10, bottom part, Roman 4.
Page 10 of
what?
Of written notes. Not this one, not this one.
আগে কিছু দিয়েছেন দেখুন।
দেখুন written notes টা দেওয়া আছে ফাইলে দেখুন পাবেন।
এটা নাও।
Yes.
এটা দিন। Yes, madam, that one. Page 10, Roman 4. Roman 4, right. It starts with compliance of 52A and section 57 of NDPS. PW1 produced the accused seized articles before the learned court and proved compliance under section 57, marked as Exhibit 9.
Yes.
He further sent samples to CFSL on very next day of the incident. Incident took place on 4th January. He sent it on 5th January. Letter was marked Exhibit 10. Acknowledgement was marked Exhibit 11. Verified his compliance through letters to Ministry of External Affairs 12 and 13. Now PW4 deposed that legal formalities under 52A was done by learned Judicial Magistrate Second Court Barashat and proved certified inventory, photographs and the representative samples marked as RS1, RS2 which were drawn in presence of learned magistrate.
And it was done when? It was done when?
On very next day, 5th.
5th?
Yes. It appears from the evidence itself.
But they are saying that 6 or 7 or something like that.
Yes, Mr. Chakraborty says it was done on 7th. PW4, if I again turn to evidence, PW4 is at page 33. My lord, page 37 is the relevant portion. Original go down register on the top. Page 37 on the top. এক্সিবিট যে ফাইলটা ওটা দিন, ওটাতে এক্সিবিট 17টা পেয়ে যাবো। My lord, kindly see legal formalities under section 52, just one paragraph. Now we need to check exhibit 17. Complaint. In 16. This is 17.
No, in the deposition of PW4 from page number 36 on 5/1/18.
26(3). Or this is exhibit 17.
Inventory. Nineteen, 28, 23, 19. The case was of 5/1/18.
2319 hours.
No, no, India.
Oh, 26, 2019.
Yes, what is this? Nineteen. It was dated 19.
March 19.
Why?
There is nothing in the evidence. My job is to confine to this paper book. I can't go beyond that.
Yes.
Can I explain now?
The inventory was done in the year 2019.
Yes.
Case is.
But there is no suggestion from the defense.
But we have to comply. We have to see the compliance of the provisions, whether it has been
My lord,
complied
at
or
the same time, your lordship kindly appreciate there need to spell out prejudice. It's all about prejudice. NDPNs means strict compliance.
Inventory was done after 1 year, 1 month, or 1 year, 2 months.
And learned magistrate, learned judge who wrote this judgment, he has dealt with this explanation that there is delay, but there is compliance. That's what said. In the judgment, there is categorical observation that there is delay.
Now tell me.
There is decision of Supreme Court on this aspect also.
Yes.
Delayed compliance.
I will not argue what law conveys. I will not argue a single
word. We need to know the law.
52 says immediate compliance.
So that has not been done here.
My lord, kindly consider one aspect. NDPS law, there is no substantial compliance. There is no
100%.
There is no partial compliance. There is all mandatory compliance because
of the draconian nature of the law.
Absolutely. I bow down to my lord.
Now tell me,
there whatever lacuna that derived from the exhibit and evidence, I can't argue on that because that is not law. That is contrary to everything. But at the same time, my lord, my humble submission would be accused has to spell prejudice. Neither in 313 nor in defense evidence. Nowhere he spelled prejudice.
Even if
there is delay, no doubt there is delay. But that delay should cause prejudice to accused.
We are asking you.
This is inordinate delay of 5 days,
absolutely
20 days.
March. That is why I handed over.
We are hearing the appeal, no?
Yes, yes.
So another thing for you, page number 36, last question. The PW4.
Yes, page 36.
36, PW4. That on 5/1/18 at around 11 hours, the paragraph number 4, I think. Have we got this? Internal page 5 of.
Yes, my lord. Yes, my lord. It
starts on 5/1/2018 at around 11 hours, I issued all seized alarms along with samples for production before the landed NDPS court at Barasa.
Yes.
In the evening of 5/1/18, I received the same after production before the court. On 8/1/18, I issued 2 original samples to Manoj Kumar Mishra for sending the same to. There is also a delay of 3 or 4 days. Why? Why this is also in violation of Section 52A of Section 52.
They tried to cover it up by saying Saturday, Sunday.
So judgment is reserved. 8 years. How many months?
My lord, 7 years, 11 months.
And how many days?
My lord, since 5th January 2018. And in the midst, he has lost his father in Nigeria as well.
Oh, why he has come
The
to this, India? Why he has come to India?
I would,
My lord, his brother.
I would most
my
humbly
lord, his
beseech
brother
for your
apart-
lordship to kindly deal with this voluntarily handed over and applicability of Section 50. Kindly do this because
But you
I
cannot,
didn't find any judgment.
you cannot explain the violation of Section 52A.
I will not. Did I say anything?
Just we are changing our
I
mind.
handed over the exhibit list because
Hey,
your
you
lordship
are-
should see the exhibit list.
Only thing I want to know, and we want to know, how fatal is non-compliance with 52A? Will that be a ground for acquittal?
My lord, several judgments are there.
I know you have not shown us those.
No, my lord, I have only relied on investigating officer was not the independent one.
Supply just if you can in course of the day.
My lord, I will supply. My
That
lord, I have
52A violation is would be a ground for
My lord, I will supply.
acquittal.
I will hand over, my lord.
বুঝেছি ওটা দিলে ওটা পাঠিয়ে দেবে সাহেবের
My lord, right now I'm giving.
চলো
এটা
হিয়ারিং ইজ কনক্লুডেড জাজমেন্ট
Grateful.
আমাকে পাঠিয়ে দেবে।
আমি এক্ষুনি দিয়ে দিচ্ছি আমার কাছে আছে ওটা।
একটা কাজ করলে হয়।
Mangilal in 2023, Mangilal, that was decided on 2023, says in paragraph 6 to 9 that non-production or non-compliance of 52A is extremely fatal, grave.
Give those.
My lord, I will give. My lord, I have in my.
He's helpful. You must be thankful to him.
No, he's very fair.
My lord, always fair. My lord, Mr. Because he also argues for the prosecution.
I'm not talking about complexion.
My lord, he also appears
But
for
my
the
lord, again I say, my lord, please deal with voluntarily handed over, whether
Yes, we will.
whether
deal with it.
tantamount to personal search or not.
No, 50 violation হয়।
There is no 50 violation.
But 52A is fatal.
My lord, grateful.
Item number 21, 23. Item 21 to 23.
Twenty-one.
1 and 23.
Now I'm put apple and milk. In all the
Appellant.
in all three matters.
21 and 23.
But this is assigned to your lordship, and it was heard. Other side. Huh? In all the three matters.
Yes, Your Lordship.
Where are the other parties? Right. We are by two.
I'm led by Advocate General in this matter, Your Lordship.
Tell us what you want to say. Don't say half the things.
Lordship, if my learned friend starts, I can very well jot down the notes, Your Lordship. My learned Advocate General will address you on some other day, Your Lordship.
Hello?
Yes, sir.
No, this piecemeal thing don't do. Then give us a date. We will fix it on that date.
Today was fixed upon the specific representation that the AG would be present, my lord. And we had also given notice thereafter because this time was suggested by the AG himself.
Last day we were not present.
No, it was on telephonic call. This time was suggested by the AG itself. Upon, yes.
Apart from the Advocate General, the state, there are other parties.
No, my lord, we are here. The other petitioner is also here in item number 22. There's no.
There is no private respondent in any of the appeals. How long we will take, Mr. Mitro? 1 hour. Then you start.
Start. No. Well, may it please your lordships. It relates to off license of a wine shop. Questions involved, tell your lordship. What are the rights, if any, of a
Excuse me for interruption. It should take 1 hour time from 3 p.m. at the other bench also. So the other appellate said matter is.
You will continue till 3 p.m.
3 p.m. Till 3 p.m.
Then other appellate said matter.
কেউ কিছু মামলা করতে চায় না কেউ করতে চায় না anyway I indicate the point although can you note down and see but lordship note a license are issued temporary license for 6 months normally it's a usual thing. What are the rights of that temporary license holder initially for 6 months under excise law? First point of view. Next point is involved whether that temporary license holder can maintain a writ petition. This point arises because one learned single judge have held they relying on some extra commercial item. Therefore, no writ lies. This is a single bench judgment, and my lord,
ওইটা থেকে বোধহয় হওয়াটা পুরো সে কিছুই তো করার নেই Yes.
And what my second point would be, that as indicating, whether that judgment of single bench should be overruled by your division. Third point is whether order of suspension of the license, temporary license, is void. These are 3 main points.
Yes.
But a temporary license, every first license, after few advertisement, etc., a wine shop is selected. Then the wine shop licensee, he has to secure a shop, which is substantial expense and all that. And then he starts. In this case, license was given upon advertisement, etc. In one case, he could run the shop for only 19 days. Thereafter, Excise Commissioner made the suspension order. And the suspension order continues till expiry of more than 6 months. He could not utilize the shop. Question therefore is, was suspension order void or not? It was issued by the Excise Commissioner on the alleged ground that the Election Commissioner has requested him to suspend only one type of license. My license was issued under Rule 4Q. Therefore, only that type of license was required to be suspended on the Election Commissioner. That I shall show you, I don't think it will be difficult to show you, Lordship, that on the ground of election, Election Commissioner cannot suspend, Excise Commissioner also cannot suspend, because what will be the suspension and duration thereof is governed by a separate excise rules. The elections are held at different districts from time to time in a phased manner. Whenever election being held, suppose in Calcutta, time limit is 48 hours under the rules. 48 hours before the election, there will be suspension. And all licenses, not one, every licenses. Not that the request of election commissioner has not seen the light of day. And we have said none, which is all fabricated. And another ground is he has no jurisdiction, and election commissioner, it is the duty of collector of the
State and excise are being represented by the same council? State and excise.
Huh? Yeah.
Yeah.
This I'm only indicating just briefly, I shall go to. Next comes the question, writ petition maintainable or not? Here my humble submission, there should be no difficulty. The learned judge, single judge, in my respectful submission, had made one very gross error or law. Although it is laid down by Supreme Court, that is item extra commercial. Extra commercial. তোমার Latin বলছো আমি ইংরেজি বলছি। আচ্ছা, extra commercial. Yes. If nobody has a right to carry on business in that item, wine, alcoholic beverage. Nobody has a right to. So every state can declare that my state will be dry country and dry state. And any person of that state cannot challenge that. And no petition will be liable. Difference between applicant for a license has no right, fundamental legal right, ask for grant of license. And next is license holder, who has been given the license by the state government, which is the weight state, they stand on different footing. The moment license is granted, his rights will be governed by the excise law. As the Supreme Court has clearly laid down, that point was missed by the single judge. And there is judgment of Supreme Court to that effect. Therefore, my lord, I'll first show your lordship the order of suspension to start with, and then, or I can show you a list of dates. So, it is not on engrossed copy. Would that a copy down? What about এক্সারসাইজ লট অফ এই বইটা আছে, এই বইটা কি আপনাদের আছে এখানে? এই বইটা কি আছে? সব এক্সারসাইজ লট। Bengal, it's governed by Bengal Excise Act and rules. Can you place the list of it? 2018, Rule 4Q was introduced. By notification, etc. 4Q added all kinds of liquor except tari or pachai from a liquor shop. If my lord now see the Rule 4Q, whatever. You. Yes. 4Q, my lord, is the categories of licenses. Heading. Unless otherwise ordered by state government, a license may be subject to provisions contained elsewhere in these rules be granted for the detailed sale of the ABCDF up to Q. So there are all kinds of licenses. Shall it not be foreign liquor shop for consumption of the sale of the site from the opium depots, etc. Bhang, correction, regulatory, foreign liquor shop of departmental store Q and G, foreign liquor shop. Then H, foreign liquor for consumption on the site, on license, omitting that, on license, off license, etc. Foreign liquor shop on the premises, the bar licenses. Then you M, foreign liquor shop off license, off and on or out can be given, etc. Foreign O, foreign liquor for consumption of the site. Then all kinds of liquor from a liquor shop run by West Bengal State Beverage Corporation. They have got it. Q. Then this is Q is added. All kinds of liquor except tari from a liquor shop. So whether this shop of license can be granted and is granted at different rules. It is not the only shop or license. So the licenses granted at the 4Q are not all the off licenses. There are various off licenses. This is the only, it's only one of them. Only one of them. So this is important because my lord, suspension order suspended only licenses issued under Rule 4Q. Obvious question is, the object of the election commissioner was to make it dry before election. Then all licenses should be suspended. By suspending only 4Q and keeping alive all other licenses, the place will not go dry. Absolutely. Now, may I continue with the list of days? I'm indicating the position below. Then brochure release, Excise Department, I give page number, etc. Then next date, number 3. Appellant number 1 applied online, paid rupees 88,000 and rupees 30,000. Was license fees. Big election. Election Commissioner could not and did not pass any order. No such order or request has seen the light of the day. If the objective was to keep the place dry, then all licenses will be suspended. Now I shall come to Calcutta law. Rules expressly provide only 48 hours of dryness before election in the concerned district.
Do the bars, the restaurants, clubs, they also become dry 48 hours before?
That is before the election, power they give me to a collector of the district where election is going to be held to suspend all off license, on license, etc. All off and on both. For 48 hours before election. That is the rule.
Clubs, restaurants, bars, everything.
Everything, on, off, everything, on license, bar, everything.
Five-star hotel. No, seriously, Taj Bengal, let us say. You get there within 48 hours of election.
We'll take it in.
The five-star hotels are wonderful.
Supposed to be Milord. But the room service in a clandestine manner is not.
Well, I'm told all.
All.
Under the rules, all. In the
All.
particular constituency, everything.
Everybody lost, but room service remains. And not the five-star hotels remind the guests that tomorrow and day after will dry. So stock your minibar now. Not on formal application, on advertisement, we got the license. Then your question arises that 21/2/2019. Appellant was granted by the collector of Nadia district temporary license for initial period of 6 months, number is given. Other appellants obtained from collector similar licenses, which are annexed, but other licenses will just this is then appellant made investment that is not really part of submission, not list of dates. That's element to get a shop. Initial pagdi, premium, salami has to be paid and all that. Then, Milord, this is the order impugned. 2nd March 2019. I've given the page number. Excise Commissioner issued an order, allegedly on instruction issued by the Election Commission, in view of impending central election, general election 2019, suspending the operation of all liquor shops whose licenses granted under 4Q only. This appellant, by that time, has used the license for only 8 days. 8 days. Now, Milord, no instruction election commission has been produced. No date of general election 2019 had been declared by that time. Then see the next date, which are submitting. After 3 months, the district magistrate collector of Nadia, in view of general election, declared dry day, prohibition on sale of liquor from all categories of retail shop. Could have mentioned the on license also. In the district of Nadia, in accordance with the timeline prescribed by the Rule 3 of the West Bengal Excise closure of retail license on special occasions, namely election rules 1990. That is page 78. 3 months before general election, this is supposed to have my license suspended. And when the rules permit only, election commission has no power. District collector has the power to make the suspend licenses on the ground of election. So, well, the suspend order is void on the ground. Then, 23rd of May 2019, general election was concluded. Even when it was concluded, thereafter my license was not revived. Suspend order continues. Therefore, suspension was made not on the ground of election, but some other ulterior motive. Suspension, etc. They made representation, etc. Representation, estimation, and those things. May I pause for timing here, my lord? Representation made, then writ petition was filed by me on 2019. It's serial number 11. And 21st August, license expired. We applied before issue of the expiry. Then after my license expired, See the date. 21st, my license expired. 22nd August, after expiry of license, Excise Commissioner issued an order, number is given, rescinding the order of suspension of licenses issued under Rule 4Q, data censor. A fact that the period for temporary license had already expired and the license could not be utilized unless the full period thereunder was noted in the said order. But no extension covering the period of suspension was granted, allowing such temporary license operate for etc. and supplementary was stated to be under consideration of etc. That consideration still continues, nothing has come forward. So at this stage, may I show you, Lordship, what are the rights of a temporary license for 6-month holder under the excise law? My submission is governed by excise law rule number 9. And then I place a suspension order to your Lordship, short suspension order. Please take the excise rule, my lord, that book. Please come to page 3.11. This is about Qaidar book. Page 3.11 of that book. Aki boy join kariye to 3.11. 9. Procedure for selection of new site for grant of license. New site. 3.11.
On the right hand side top corner, page number.
Which are the rules which are relevant? 2003 rules or
West Bengal X
3 rules.
2003 rules. It is known as West Bengal
but suspension was under 2019 rules.
2023 rules. It starts at after page 2.191. 2.1. Lost to see in the nomenclature at
we see
after 2.9.
Again, serial number 7 in your list of dates, you have mentioned 1998 rules. That is
1998. Oh,
This is the closure rules.
correct.
Did not
Closure.
stand under the closure rules. They did it. They just did it without citing any.
It's a rule for granted. The closure rules is governed by Rule 98, which make 48 hours closure.
Show us that later. Show us that.
Yeah. And this is the rule. The West Bengal excise selection of new sites and grant of licenses for retail sale of liquor and certain other intoxicants rules. Excellent. Everything is clear. They have read Boikuntar Khata, Pracho, Paschatto, Pratina, Pratin. Nothing is left out. They have followed that. Now kindly come to page 3.11.
Xerox copy of the bare rules.
Bare rules, my lord.
Bare rules.
The rules gulo photocopy kore.
Acha. Bare rules দিয়ে দিও. First, Mr. Stanley, come to 3.11. Rule number 9. For selection of new sites. Subject, our case is new site. Subject to such instruction as may be issued by state government, excise commission from time to time. If the collector is of the opinion, having regard to the general trend of consumption of liquor and other intoxicants as specified in sub-rule 1 of Rule 2 in a local area or its adjoining areas, that it is necessary to grant license of any number and any category referred to in clause 8 and C to M of Rule 4, Rule 4 of any number and categories referred to in clauses A, C of M Rule 4 at certain new sites within the local rules in order to meet the demand of such area or adjoining area. He shall, for the purpose of the selection of new sites by the state government under section 30, or selection of new sites within areas specified in state government under section 14, as the case may be. Prepare a preliminary list of local areas within such, in his opinion, is any state. Provided preparing, that is, I'm omitting that portion. Kindly read the third proviso at the next page. The provider. Provided further, all applications submitted for the grant of any license of the category specified in clause DD, extra K and Q, also of Rule 4, shall initially be treated as an application for grant of licenses, temporary for a period not exceeding 6 months. And customary process, etc. Then what is the, after obtaining licenses? Then A is the duty of the licensees. B is after obtaining applicable information, etc. Demand of the local areas, etc. Then without during period, then kindly come to F. It's important. What are the rights and duties of such temporary license issued in a port queue? F. Grant of a regular license may be considered after the holder of such temporary license has run the same for a period not exceeding 6 months. After the collector is satisfied that the revealed demand justifies the location for the grant of a regular license, and subject to the collector's satisfaction that the application merits recommendation, the collector may, in such cases, recommend the proposal for grant of a regular license and send the same to the excise commissioner for approval. After receiving the approval, excise commissioner, approval of the excise commissioner, collector shall grant the regular license after realization of fees applicable new, etc. Pausing here, my lord. After, during the period of 6 months, license issued on the basis of an assessment of demand in that particular area. Maybe to assess that if here 1,000 bottles will be sold or something. Now, the temporary license holder during the first period of 6 months, if the sale is as estimated, maybe more than 1,000 or less, then he will decide whether that area really deserved the license as per estimation made. And we find that yes, estimate was 1,000, sale was 1,000 or more than 1,000, then he will collector will apply to the commissioner that let him give him regular license. And commissioner with the approval of the excise commissioner grants the license. Then we'll see G. If the collector recommends and sends the proposal to the excise commissioner for the grant of a regular license for the remaining period of the settlement year or the next period of settlement, he shall issue further temporary licenses for period not exceeding 6 months in favor of holder. Such fresh license granted on temporary basis not exceeding 6 months shall be continued to be granted till receipt of an order of approval, and shall be continued to be granted till receipt of an order of approval or rejection of the excise commissioner. So if the excise commissioner delays the matter, is not approval is not forthcoming, then temporary license will be given to him for the interim period until order of rejection comes or approval comes. Then, in arriving on the opinion, then collector may hold such inquiry as deemed fit, subject to direction from the court, may be issued by state government from the time to time, subject to that. If then provided that time of proceeding, there should be grant or retail license, the rules, then collection will include proposal in the preliminary list, then collector shall send the list, excise commissioner shall forward the list to the government, state government shall finally consider, etc. Provided. So, but can you read the rule? I'll wait to read the rule, then I'll make my submission. So, my lord, my humble submission is this. Licensee under any of the rules, including 4Q, upon getting the license has a legal right to apply for regular license. The right is given by the statutory rules. And the criteria for determination of regular license also governed by this act. Namely, see what the demand in that area was as estimated. If the demand, in other words, if it's shown during the first 6 months, that licensed shop has sold, it's just the estimated quantity, volume of alcoholic beverages, then demand is justified. Demand as estimated, justified. Then collector recommend that to the commissioner. And commissioner shall approve. Let us put it, my case very mildly, at lowest bottom. He has got a right to apply for regular license and consideration of his license in accordance with law. Yes. So, my lord, it is not a case where temporary license is granted. He has no right. After 6 months, it goes off. There's no right thereafter. But if during the 6 months, his license suspended, after only 8 days thereafter, in another case 19 days, then, and the suspension has to be void, then it should be given the judgment of our division bench of Justice Gonan Rai was given before the excise, before these excise rules, because before the right became statutory. He gave the judgment, also gave the judgment basis, the law of legitimate expectation. His lordship said nobody gets a license for 6 months on the expectation they will run the shop for 6 months only. On that basis, and make investment huge amount, take the shop on hire, that main expense, investment, and employ the staff. Similar, everybody takes the lab license with the expectation that after successful completion of the period, his license will be renewed, either from year to year, temporary period, until approval of commissioner received, or upon receiving approval, final period. This is the position, my lord, on that. Therefore, my lord, the position of a license holder and the position of applicant for a license are totally different. That is, my lord, single bench missed. The vast difference between the license holder and the applicant for a license holder is totally different. An applicant for a license holder cannot say, I must get my license matter of right. Particularly in the states where it is declared dry, etc. But the license holder can say, I have my right in accordance with law. I have such rights as have been vested in me under excise law. Such rights are regular license and temporary license until regular license issued. Now, my lord, kindly come to the suspension order, which is alleged.
68.
Wait. Page 68 of the stay application. But 1992, sir, I got page 68. It dated 2nd March 2019. ওঠেনি ভালো। In view of impending general election 2019, my lord, kindly now remember, impending general election was held in the district in the 15th April. And he is issuing the order on 2nd March. In view of the impending general election, various instructions issued by the Excise Commission of India, that no such, kindly note here, no instruction is disclosed, restricting the distribution and storage of liquor and to curtail the availability of it, right? During the process of conducting the election, I, the Excise Commissioner of West Bengal, exercise the power conferred by the state government and the provisions of Bengal Excise Act. I show you lots of he has no such power. Do hereby order the operation of all liquor shops granted on and from January 2019 under category 4Q under the West Bengal Excise Selection of Rules. And object is to curtail the availability of liquor during the process of conducting election. And only one category of license is suspended. On license, off license, or other category remain. Expressly similar, discriminatory, and object to contrary to the has no reasonable nexus with the object.
Yes.
Technically, without for pausing here, he said in exercise of power under Excise Act. I will press Excise Act. Also see, Excise Commissioner has no such power. Suspension of an excise license granted can be on specified grounds. Now, let kindly come to Excise Act, the year section 42 of the Act. Okay. 42. Now, section 42, my lord, that page
115, my lord.
Page 115 of that book. What are the power to cancel or suspend license, permit or pass? Subject to such restrictions, a state government may prescribe by rules made under section 85 and subsection 2 clause etc. Authority Kalima, who granted any license?
Collector.
No, collector. Yes, well, collector, not the excise commissioner. That's I've anticipated the point. Yes, a collector. permit or pass under this act may cancel or suspend if it is transfer sublet, duty not paid, breach of any rules, conviction, holder thereof is suspected penalty, nothing. For a license permit, if the condition of license permit, suspension at will. At will. This license doesn't permit that, place that to your lordship. But even then at will. And so holding of election is not a ground to suspend. Because that power is given by separate rules. Is governed by separate rules. Now see that rules, my lord. Rule 98 কোথায় পাবে? At page 3.306. 3.306. In exercise of powers conferred by subclause 6, clause 9 of section 86 of Bengal Excise Act, as delegated to the Excise Commissioner, so powers given, West Bengal by subclauses 3 and 14 of the consolidated orders made under the provision of the Act and published through notification such as amended up to date. I, Excise Commissioner is making the rule, do hereby make the following rules with immediate effect in supersession of the rules published through such as amended. Rule number 1, called name is given, nomenclature. Again, very explicit nomenclature, Boykuntar Khata follow koritu sob. Notwithstanding anything, etc., this rule shall take immediate effect. None of, and 3 is important. Notwithstanding anything contained in any other rules or notification, the retail license premises for sale of any country spirit, color spirit, pochai, beer, bhang, foreign liquor is coming to us through off shops, foreign liquor through on shops, foreign liquor through the bars attached to hotels, restaurants, motels, pub, club, cinema hall, tourist lodge, any other place of public resort or entertainment, dark bungalows, the bungalows and etc. Then Simon shall be kept close as detailed in table below. General or by-elections of the Bidhan Sabha during the period of 48 hours, ending with the hour fixed for conclusion of the poll within the territorial jurisdiction of the concerned constituency, where polls are held. And then Lok Sabha during the days of counting of votes in the concerned jurisdiction. Counting of during the days of counting of votes in the concerned jurisdiction.
Yes, sir. So you have challenged this
Order of suspension.
Dated 2/3/2019.
Yes.
So when you have filed this writ
To
application,
2019, a long time back, immediately after. Before expiry of license, we have applied.
after 6 months, I think.
Writ petition was filed.
So after 6 months,
No, writ petition was filed. Can you take the
no,
date?
when the writ petition
It was filed 2019.
date?
Before, I also get the date here. 19th August 2019. My license was then valid. Period 6 before expiry of 6 months. Could not be heard.
I waited. You made representations.
Yes.
We made representation and the writ petition, my lord, is pending. What happened in the meantime, a bunch of similar writ petition arising out of other districts were taken up and disposed of by a common order. My writ petition was not there. I had assailed that order being a third party.
No, no,
in
that
the
disposed of
That was
and
disposed
it was dismissed. On the ground, I told you that no right. So when my application came up before another single judge, he was bound to follow the judgment. I showed the judgment. He's only on the ground. There's a judgment of another single bench. I am bound by committee of courts. Therefore, my lord, now this case involved.
And that earlier judgment was not tested in appeal.
No.
That it was tested in appeal, my lord, by others. Those appeals were withdrawn.
Appeal withdrawn. Appeal withdrawn. Not tested on merits. I'm not.
I'm told not all of them have been.
I'm not. Last time, I didn't even state government did not support that judgment on that ratio. Anyway, my lord, the judgment expressly wrong. This is the second point involved. So I'm now showing suspension order is without jurisdiction on ground number 1. The license was not issued by the excise commissioner, by the collector. Therefore, excise commissioner had no right to suspend. Number 2, the ground of imminent impending general election is not a ground for suspension of license under section 42 or otherwise. Because a separate rule prescribed framed by excise commissioner himself says limits the power of suspension of license, limits, curtails. 48 hours, Vidhan Sabha election, days of counting, general election. Limits.
This was actually done in
And my lord, this order and for suspension of all this license in the concerned district of election was actually passed. She will not kindly come to page 75 of the state petition. That was passed on 15th April 2019. Dry day, declared dry day. And issued by the collector. Page 75. Similar area covered, period mentioned.
24.
In some cases, 24 hours, etc. Some cases, whole day. Some cases, 24 hours. Till the end of poll.
48 hours.
48 hours. Maximum 48 hours. নোটটা কোথায় গেল আমার? নোটটা এখানে আছে।
না, এটা না।
হুম। When the power to suspend a license is circumscribed by the statute, by law, then it can be suspended only in accordance with that statute and not otherwise. So, when the excise commissioner says, in exercise of my power under Excise Act, I am doing it, it is a wrong statement. So, he had no power, that is why null and void. Secondly, he had not issued the license. Collector is to suspend, not him. There are 2 grounds. Third ground is more serious. And if it is, even if excise commissioner had the power, it is order is expressly discriminatory, violative of Article 14. Why? There are 17 categories of license shown your lordship, including bar license, on license, off licenses. How will suspension of one category of license help to make the country dry, to make the place dry? And why select only license under 4Q to be suspended? Why not license under 4F? Why not license on licenses? There's no reason given. Expressly, my lord, has no nexus with the object or purpose. And secondly, it is value Article 40. If he had at all jurisdiction,
The 98 rules
98 rules
provides for a blanket prohibition.
by excess
All
capital
kinds
will-
of.
Right.
Yes. It is now I may humbly add, this is violative of 98 rules. Because the power is circumscribed up to 48 hours. It's violative of the 98 rules also. So that is void. And only after 8 days it was done in one case and 19 days in another case, which are both of which are before Lordship. And
How many appellants are there in the first appeal?
6.
6.
License is annexed. I show you, Lordship. License is annexed. I've shown you. And shall see who has issued the license.
No, but it will vary, no? How long
Huh.
one appellant could.
Maximum, my lord, was 19 days.
19.
Sir, attendance
Hmm?
4QA rose granted on and from a particular day of January 2019 was suspended.
Kishe reta?
The suspension order.
This is not a fit case for my learned brother.
It is like that good. It is like that.
I get irritated by this man.
He's a fierce teetotaler.
Do you take benefit of any off license or on license? Is that this question? Are you benefited by any off license or on license?
No, that will come.
We are all off license holders.
Older.
No. Ulto re. You're off that article of that thing.
Yes, all.
But off license means something else. You don't take benefit of either off license or on license. Correct. A dry person. It under dry. Well, this is second point. Third point is this. Now see the order under appeal. Order under appeal. D'accord. Can you take the memorandum of appeal? Memo appeal. Annex to the memo appeal. Page 26.
আমাকে না যখন দেবে দয়া করে একটু কেটে দিও আমি না হ্যান্ডেল করতে পারি।
দেবে তো? এবারে বর্ষাকে জাজমেন্টটা কোথায় calculator?
139. 139.
Paper will take paper যখন দেবে কে?
Yes.
Page 26, my lord. Writ petition is considered in presence of learned advocate representing the petitioner who relies upon the order of the Honorable Division Bench dated 1st April 2024. Passed into two intra-court appeal. The order is given by the Chief Justice. And I show you that which is interesting, which was directed against the judgment of a coordinate bench dated 27 September 2019. According to the petitioner in the present writ petition, similar issues have been involved, which was considered by the coordinate bench while delivering judgment dated 27 September 2019, disposing of batch of writ petitions in apostate two intra-court appeals prepared by the petition number 7 in the present writ petition. Honorable Division Bench granted leave to the appellant to get the present writ petition disposed of in the light of the judgment dated September 27, 2019, which whatever
Which led the learned advocate.
led that representing the petitioner to bring it into the notice of
Let
this
us see the
court.
27th September judgment. That is the real one.
That is the and the order of Supreme. What happened in the background, Your Lordship? We wanted to prepare an appeal on the order of single bench.
Which one?
involved-
27th September.
Yes, we involved lot of delays, and government opposing Section 5. So Chief Justice, the previous Chief Justice bench, they suggested, advising order. Why do you bother about it? You file a pending, move it before single bench. You will dismiss this on the basis of this judgment. Then you prepare an appeal. That's his advocacy was there then. Then not. So order says your application Section 5 is named, and you apply before that. Petition get applied with the heart. For which and the order dated census passed by division bench placed before this court, and we have feel bound by it and do not. So now, Milord, only the question is that the single bench judgment is to be overruled by division bench, and I shall submit. Yes, it is expressly bad.
We have to see
Page
that
139.
27th September.
Yeah.
Okay, page 139.
And don't think you are supporting the single bench judgment, Mr. Advocate. Boshaketta. Page 139 of the state petition. আগে তো করুন আগে সাপোর্ট করুন জানি আমি পেজ come to 139.
Page 139, state petition, bolo.
Of the state petition.
State petition.
139.
At page 141. And I cite Supreme Court judgment, so it is contrary to Supreme Court judgment. Page 141, Lordship, kindly come to. Mr. Vikas Ranjan Bhattacharya, Lana Sinaka, etc., submits that petition is a temporary liquor license holder. Such liquor license was suspended for a temporary period on a specific ground of the impending general election by a notification dated 2nd March. Excise Commissioner did not rescind the notification dated March 2, subsequent to the general elections getting over. Petitioner approached the writ court. Such petition was disposed of by an order dated July 3, directing this commissioner to reconsider his decision. He submitted the Excise Commissioner by order dated 23rd July 2019, purportedly passed in conformity with the order dated 3rd July, called for reports from various authorities. He submitted the Excise Commission acted in excess of jurisdiction in doing so. He submitted that the writ petition thereafter approached the writ court for second time by another application, complaining that the Excise Commissioner was delaying taking decision in the matter subject. Thus, the petition was disposed of by an order dated August 2, 2019, requiring the Excise Commissioner to take a decision within 3 weeks. He submitted the Excise Commissioner by in writing dated August 22, 2019, rescinded the notification. An order of court. He did not revive the liquor license. What use of rescind? By the impugned order, Excise Commission expressed the view that he wants to re-examine the application for continuation of temporary license, subject to the condition restriction contained in the new site rules. He submits that such an exercise is not permissible. He relies upon Rule 9 of the new site rules and certain other rules, and submit the selection site is completed prior to the issuance of the temporary license. Correct. Moreover, authorities consider this aspect of demand and supply prior to issuance of temporary license, prior to issue. Consequently, impugned order dated 22nd August is beyond the powers vested upon the Excise Commissioner and consequently must be quashed. The petitioner invested huge capital in foraying into the type of business. Petitioner cannot be left high and dry by such whimsical and colorful exercise of powers. He therefore seeks a direction upon Excise Commissioner to revive the temporary license exercise existing in favor of licenses for the remainder of the period of such temporary license. Remainder period. Is a Joydeep Kaur. His argument is noted thereafter, my lord, on behalf of the state, I think. Another party is supporting it. I'm omitting that. Then Mr. Advocate, additional advocate will make the argument. We start, my lord, at page 5, bottom. And please come to page 6 as learned additional solicitor, advocate general. According to him, authorities select a person to whom license may be granted in terms of Section 37A of the Act. Then his argument noted. No, he submits that a person is elected is required to have the requisite infrastructure. Admits that. Therefore, a person have been granted temporary license initially or license under Rule 4Q cannot claim any promissory estoppel. I am not claiming promissory estoppel. No promissory estoppel is asked by me also in this case. A matter of right, I will get it. He submitted the provision of the Act, dated, etc. And then he goes, making an investment for this purpose to become qualified to apply for license does not mean that state is requested to grant or extend the license. He submitted, having obtained license, the person, this is the point, does not have vested right to carry on business. This is wrong. License is merely a privilege. It does not give rise to a right. Wrong. Excise law, that's what I've shown to your lordship. Totally wrong submission. Excise laws, Rule 9. He refers to rules of 2005, various and Supreme Court authorities. Petitioner does not have fundamental right to any carry on business. No. No because of fundamental right. Because of legal right, statutory right. For that petition is maintainable. It's not Article 32. Fundamental right need not be. Petitioner carry on. License merely a privilege. Doesn't give. These judgments are cited. All these judgments will not. All judgment in this case were not. There's no license granted. Applicant for license made the application. In some cases, for a dry country, why dry you should declare? All these, none of them license holder. Additional government general argument noted. Kindly, my lord, come to reply is noted. I'm omitting that. Kindly come to ratio. Yes. Time period complete. Yes. The Amla learned that considered, etc. Kindly come to page 10. Nandilal Jaiswal judgment is of the view that there is no fundamental right in a citizen to carry on trade or business in care. Same 75-1. I'm conceding that. No problem. Then Milord realized another 1991 SCC. Then same thing. Excise privilege, it is a privilege, not merely a license. Then Devan Motors, he reported in 2024, which is in light of Article 19. It is of the view that permissive privilege to deal in license is not a right at all. Dealing illegal, neither a right, not a kick. That's like, no problem. Distillery license. Then all these judgment, my lord, is of the following view, all see it. Northeastern, etc. Now we come to ratio of the learned single judge, page 14. After considering all those judgments, notwithstanding licenses granted in favor of the petitioners being a privilege, which is the mistake, with no right accruing thereon. This is the point. No right, excise rule. The action of the state taken with the regard to such license are to be tested on the in attached on Article 14 of the Constitution. If the action taken by the state fails such states, then such action can be struck down. Article 14 applies, he admits. Very good. In the facts of the present case, petitioner obtained temporary license, Rule 4Q, on and from January 1, 2019, and subsequent license general election intervened when, that's not noted, by an order dated 2nd March 2019, Excise Commissioner suspended the operation of license granted on and from January 1 under Category 4Q rules until further orders. The reason stated in the order is instruction issued by the Election Commissioner, not disclosed, restriction the distribution, etc. Evident general election 2009. General election 2009 being over, did not suspend, did not keep did not
Suspend or rescind the order dated
order dated, etc.
2nd March 2020.
Then goes on. Yes. Now, Miller, carry on. Can you come to the order lift the suspension? Suspension rescinded August 22. However, such impugn order did not revive the license grant, etc. The next, since inception, Excise Directorate classified 4Q license holder on and from January 1 as a category. Such classification on the face of it cannot be said to be unreasonable, perversity, or arbitrary. Justification of classification such license for advance on behalf of Excise Commission is that Excise Directorate received substantial number of applications on and from January 1, 2019, and that they amounted to about 750. Prior thereto, Excise Directorate granted license and Rule 4Q about 45 persons. Sheer number of side license is a plausible reason for the classification. Therefore, there subsists same justification in the classification undertaken by the Excise Directorate in classifying licenses under Rule 4Q of the Rule Code on and from January 1 and treating them separately. That, to which my respectful Milord, I disagree, and whole Lordship will also disagree. Some of the license under Rule 4Q approach are it code, then history is given. History is given. The repetition. Or the express extra. Or should let it. Extra evaluation, etc. Then it is the contents of the petitioner. Then the last but one paragraph. Given that I'm on page 16, Milord, of the Act, etc. The last paragraph important. Act of 1990, that is Bengal Excise Act, allows closure of shops temporarily. Such powers can be found in Section 26 of the Act of 19, Bengal Excise Act, I'll show you, Lordship, immediately. Authority granting the license can cancel or suspend into Section 42 of the Act. So for closure, Section 26, that is, doesn't apply in our case. This suspension, Section 42. Section 21 is quoted below. District magistrate or a subordinate magistrate or chief metro magistrate or the commissioner of police may by notice in writing to the licensee require that any shop in which any intoxicant is sold shall be closed at such times or for such period as the magistrate or the commissioner of police may think necessary for preservation of public peace. There is no application. Preservation of public peace is not the ground for closure of my shop. If any riot or unlawful assembly is apprehended or occurs in the vicinity of any shop in which is sold, any magistrate or the police officer who is present may require such shop to be kept closed such period. When a magistrate or police officer makes a direction, etc., also see expressly has no application. Order is not passed, suspended or not passed by any magistrate or police officer.
Mr. Mitru, we'll have to stop today. Just one last question for you.
My lord.
We have read the order. We have gone through the entire order.
Yeah.
I'm
reading at page 18.
At page 19, the learned
19, yes, 19 starts, yes. 19, yes, that's the second. My lord, right.
No.
It is the contents of petition.
We have gone through it. We have read the order.
No, read it. Then
Yes. The learned judge records that the excise commissioner proceeds to say in the impugned order that the excise directorate is considering allowing the temporary licenses to operate for the remainder of the period. And for such purpose, it is taking into consideration various factors. It is essentially re-examining the licenses.
Yes.
Now, this exercise, did anybody hear anything from the directorate? Nothing.
No, the state government is representing.
Well, we'll carry on. We have read the order. If you have anything more to submit on the next date.
Yes.
Lordship, I'm being led by Mr. Chakraborty.
Shono.
Excise commission appear করতে is appearing for. এটা বলতে নেবেন না।
না আজকে না।
Yet to come to exercise. Time expires, allow 10 weeks time to consider the order. 10 weeks from 22nd August 2019. Just kindly come to page 135 of the state petition. 135 of the state petition. The order is there.
My lord, by an order of court.
Order of court.
The single bench.
And not this bench, another language judge. 135. Kindly come to order, page 135. Oh, what?
Mr. Anindo Kumar Mitro, learned senior counsel, representing the appellants in our
21 and 23.
21 or 23 item number গুলো দিয়ে দেবে appellant 21 আর 23 হ্যাঁ Mr. Chakraborty, when one dictates, kindly don't interrupt. It really affects the chain of thought. For the appellants in appear such and such, begins his argument but does not conclude. Tomorrow, Mr. Mitro, shall we keep...
Yes, what time?
We can't fix time. It will be before the group 9 matters. I mean, before the other group 9 matters.
Tomorrow.
আগবে কিন্তু কোথায় থাকবে বলে দিলাম তো paragraph list the matter once again, list the matters once again, কালকে date দাও before other group 9 matters.
So likely to time it out to 12 p.m. or before 12 p.m.
Mr. Mitro, we have such a heavy determination, it's impossible to say because we have criminal, we have bails in connection with appeal, we have admission of appeals, criminal appeals, we have criminal appeals. So
may I take it 12 p.m. would be the earliest?
Not before 12.
Not before 12. Very good.
Before 12. Very, even if it comes before 12,
yes,
we will accommodate you.
No, by 12 I'll be here.
Yes.
Normally I'm a little slow in the mornings.
You ask your juniors to keep track. At 12 o'clock, another matter is fixed. Mr. S.N. Mukherjee's matter.
At 12, then
this will be after recess, perhaps.
Of the same bench, my lord, subject to correction. That
The other
that matter to my lord is hearing.
Then it will be Friday.
Bench আছে মনে হচ্ছে।
Then we'll keep it on Friday, Mr. Mitra. Friday.
Friday, very good. That's better.
Friday.
Friday,
যেটা বললাম group 9 এর উপরে।
Okay, very good. Friday in the morning it may be. Very good.
Learned Advocate General will not be there on 14th.
চলে গেল কোথায়?
Mr. Chakraborty, we can't help. We try to accommodate as much as we can. We can't help. Be prepared to argue.
তুমি তো আছো। Friday will I come back. Okay. এটা আমার বুঝতে। The time for that exercise, as mentioned, has expired. Time
Will he be there on Monday?
Friday.
Said, according to him, he will be Monday. He will be there. 17th, he will be there.
Mr. Mitra, AG is not there on Friday. Let it be Monday.
Monday. Very good.
Monday.
Monday morning.
Monday morning করে দাও। Monday দিনে কাজ করতে।
হ্যাঁ লাগবে। আগে তো করো
State to state.
Monday then come back.
Monday it should be fairly early. 11,
Yes, I'll come.
12.
I'll be sure.
12টার আগে হবে।
No, আমি
Original site matter, new application item number 1 and 2.
Lord, before the list is called on your lordship, before the list is called on, may I have your lordship kind leave to mention the matter, your lordship. My lords, please kindly recall I mentioned this matter day before yesterday for correction of the order, your lordship, wherein APOT has gone as APO.
Hold on.
Yesterday it was not listed, your lordship.
What?
It was not listed, your lordship.
দেখিয়ে দাও লিস্টটা খুলে। If we show you it was listed,
Lordship, I have.
then we will never correct.
Lordship, I have personally seen the list.
Somebody appeared yesterday.
Lordship, I apologize, but your lordship, I will just check it.
Your apology will not do. But you don't do your homework. দেখিয়ে দাও।
কিছুই কেউ পারো না।
Lordship, this is the incorrect APO, your lordship. We are for APOT, your lordship.
You want that correction, you want that T to be added.
No, your lordship. Your lordship.
Anyway, the matter was listed tomorrow, whether correct or incorrect.
This is not our matter, your lordship. This is not our matter, your lordship.
This is not your matter.
No, your lordship. Lordship.
আরে ভাই বুঝে নাও কি বলছে আমি বুঝতে পারছি।
Lordship, APO 115 was later listed as APOT 115, your lordship.
আমাদের লিস্টটা কল করো করে বাইরে গিয়ে বুঝে নাও না।
New application item number 1 and 2.
This correct number is
this
They are for the appellant, Lordship. We are for the writ petitioner.
This matter, my lord, Learned Advocate General had mentioned it yesterday. My lord had mentioned it. If convenient to the court, honorable court, can be taken up tomorrow, my lord. My lord, he had mentioned.
That he did.
I had a talk with Mr. Mujumdar also. I had communicated this to Mr. Mujumdar.
Mujumdar?
Abrotosh Mujumdar is leading.
Have we heard it? No, we have
not. My lord had restored
the appeal. Lordship would recall where the Revocation Act was in question, and the advocate.
Oh yes, he wanted specific instruction. Relying on
Lordship.
All right.
Tomorrow. I'm great.
Your lordship, I appear on behalf of item number 2, your lords. Great.
Item number 3.
Please, my lord, I appear for the appellant.
Well, this is an order, Lordship, where we had challenged a declaration of fraud under the RBI Master Circular.
Why 2 GAs?
Well, we have filed an application for condonation of delay, Lordship. There's a delay of 39 days, my lord.
Have you served that?
Lordship, we have.
You are from Reserve Bank,
Axis Bank.
Axis Bank.
Who is for the Reserve Bank?
My lord, I filed my affidavit. My lord, here it's really against the Axis Bank only. My lord.
I don't take a vaccine. You don't. By notice at least. Personally.
I can't say anything, Lordship.
We are not inclined to take up this matter on the personal ground of one of us. Amar Namdar. Paragraph, let the matter stand released from our list and be placed before the Honorable, the Acting Chief Justice, for appropriate direction. তাড়াতাড়ি এটা যাতে সার্ভার হয় দেখো তাহলে ওরা অ্যাসাইনমেন্টটা করতে পারে।
Grateful, my lord. Grateful.
Item number 4. My lord, in this matter, I appear for the appellant. My lord, I have instruction to withdraw this appeal.
It's wonderful instruction, if I may tell
We are
you.
on the
My
respondent
lord, the
bank.
written instruction is there.
And what a lovely brief you have.
No, they're fighting it out elsewhere. We are
No,
fighting it out
elsewhere
different.
means before the learned
Read
single
code.
judge.
The learned advocate for the appellants says that he has instructions to withdraw this appeal. Stop. Let the written instruction be kept with the records. Paragraph.
I have not preferred any
APUT.
opposition to the.
Huh?
I have not preferred any opposition.
I'm
Kindly read
withdrawing.
records.
They are withdrawing the allegation.
Very well.
APO such and such is dismissed along with GA1 of 2023.
I'm so grateful, my lord.
Great.
অ্যাপিয়ারেন্সটা দেবেন অ্যাপিয়ারেন্সটা না দিয়ে চলে গেল
Look, next.
না 3 নম্বর
Item number 5. My lord, item number 5, I appear for the appellant. This is an appeal against an order passed by the learned single judge whereby my writ petition was dismissed. On the ground of delay, solely on the ground of delay. The writ petition was filed challenging the declaration of willful defaulter. My lord, such impugned order was passed on 24th of April 2023. So, my lord, there are two aspects to the matter. If my lord kindly sees the impugned order, the learned single judge has not gone into the merits of the matter because of the ground that there is a delay of 5 years in preferring the instant writ petition. However, my lord, no such opportunity was accorded to us to an extent by way of filing any supplementary affidavit to explain such delay. My lord, my main ground in appeal is that delay can't be a bar to an extent from entertaining the writ petition, can't be a sole bar. So, my lord, once that hurdle I cross, then if my lord is with me on that point, then I will address my lord on the merits of the matter. So, my lord, if my lord kindly takes the impugned order.
Allow us to read, Mr. Goa.
Yes, my lord.
No, it's go.
My lord,
Hey,
allow me to place.
what allow? We are not taking this up. Hey, same ground, release karo. Bank, the bank.
I bow down.
Grateful. Item number 6. Pass over.
Pass over.
Item number 7.
My appeal, my lord. This is, my lord, against declaration of my client as a willful defaulter. But I had challenged it. I challenged, my lord. I succeeded.
I'm for respondent.
All the respondents?
Yes. If I kindly keep this matter on the next week as the AOR is having some personal issues.
Who?
Sir Moinak Bosch, Lordship. We are led by him. So
He's just right behind you. Yes, 7, Mr. Bose. You're in 7.
No, my lord.
What is she saying?
She says I'm there, but I was
Yes,
aware that
that's what intrigues us.
My lord, may I
You or are you not there?
intrigues me as
To
well.
ascertain that, we'll make it not this week.
My lord, may I just humbly submit this, my lord? My lord, I had succeeded before the lower court, my lord. The declaration was set aside. That I had taken 4 points. I succeeded only on 1 point. The other points are vital because, my lord, that is I'm suffering on that ground before the National Company Law Tribunal, my lord. My lord, I want this to be heard, my lord. Kindly fix any day.
Your appeal may not be maintainable then, Mr. Singh, because if this writ petition has been allowed, maybe just because some points have not been decided or decided against you, find out there are decisions. This appeal may not be maintainable.
I'll check that, my lord, but
Check that. You have succeeded.
my lord, may I just indicate what was the point?
No, you may not first tell us, show us that this appeal is maintainable.
Very well,
When
my
you
lord.
have
On this
succeeded.
aspect, my lord, kindly, may I come back tomorrow?
Tomorrow? Not today?
Tomorrow. I am
Very
for
well.
the bank. Ascertained.
Tomorrow?
I shall come back.
Ascertained.
Not today.
You please also consider, Mr. Bose, they have succeeded.
Yes.
They had urged 4 points. On 1 point, they have succeeded. Writ petition has been allowed. He wants us to decide the other.
Justice Shamsuddin Ahmed's judgment, which says that if the result is in your favor, you don't have a right of appeal.
Yes,
If
there are.
I would have appealed, they would have had a right of cross
Correct,
objection.
correct. There are other higher authorities also.
Yes.
I'll
Check
check,
up,
my lord.
check
I'll check. Thank you.
রিভিউ চাই দেবে
এ তো ওর কাছে গেছে আজকে। হ্যাঁ? ডাকুন আপনারা, ডাকুন।
Item number 9.
বসে থাকো কেন ডেকে? দেখছো তো কেউ নেই।
Item number 10.
Well, item number 9, my lord.
9?
The 9 is, my lord, an appeal, my lord, against an order, my lord, refusing to reduce the quantum of penalty. Well, I'll tell you, lordship, what happened in these matters. My lord, there's a, my lord, provision in the Companies Act which requires that, my lord, every public limited company must ultimately appoint a, my lord, company secretary. And, my lord, because my scale of operations was very, my lord, very small, and, my lord, because the Calcutta Stock Exchange was not really functioning, it has now become, my lord, properly defunct. Well, I did not, my lord, appoint a secretary for a long time. My lord, then I received the notice. As soon as I received the notice, I took steps. I could not, my lord, find a person who will come and be the company secretary of a small organization like mine.
How much have you been fined?
Well, at the maximum, my lord, penalty, 20 lakhs, 5 lakhs per person, that's company 5 lakhs and 3 directors to 5 lakhs each. Now, my lord, there is a, my lord, decision of, my lord, the coordinate bench of our court. And, my lord, which says, I'm sorry, my lord, this is single judgment.
Single judge.
My lord, single judge, my lord, which says that, my lord, you must take into account all these, my lord, circumstances and come to a question of, my lord, what should be the appropriate amount of, my lord, penalty levied. My lord, it's on the doctrine of proportionality.
There is no appellate authority.
No, my lord, but, my lord, Supreme Court has also said, while, my lord, there is no discretion, my lord, as to whether, my lord, fine will be levied or not, there is certainly a discretion in the matter of, my lord, extent or quantum of fine to be levied.
We'll consider today 3:30. There's a fixed matter, we are told.
Yes.
So your matter, 3:30. Oh, so we can't hear this. Then we can't hear both the matters.
No, your lordships have called the matter. So, my lord, 10, 11.
Who is
10, 11, and 12. My lord, there are 3 matters.
I'm appearing for the respondents in 9 and 10. My lord.
9?
9 and 10.
10,
This
11,
matter,
9
the
and
next
10 are
matter.
related matters.
Related. Next 3 items are, my lord, 9, 10, 11 are related matters.
9, 10, 11.
Common order.
All fined for non-appointing secretary.
Well, 9, 10, and 11 are, my lord, similar.
I see.
11 is my matter.
So just we'll say not today, come if tomorrow or day after tomorrow, whenever.
Well, we'll come back.
So deciding one appeal, we'll decide 3 appeals.
Yes, yes.
Very good.
I will not for the points in 9 and 10.
No, my lord, one appeal was decided. In respect of that, both the other matters have also been
Well, lord,
decided.
there was only one judgment passed, and, my lord, the other, my lord, 2 writ matters followed that judgment. So, learned single judge said that in view of the judgment in, my lord, number 9, my lord, 10, 11 will be similarly decided.
GAs are stay applications. All papers are before us.
Yes, yes.
We'll hear out the appeals. So paper book fine.
Yes.
Everything, my lord.
Well, lord, there was an interim order passed by this, my lord, by the division bench, which says you deposit the entire 20 lakhs. And then we will hear the appeal. So, my lord, we deposited the entire 20 lakhs.
In
There is a
court,
stay.
in court.
Yes, yes, my lord. Quoted deposit?
Yes, my lord.
Well, lord, the entire amount deposited. Well, lord, in terms of the order of the division bench. Well, lord, thereafter directions, well, lord, order, operation of order stayed, well, lord, realization. And, well, then paper books directed to be filed.
Hey, Lekhoto, we are told that this appeal is ready for hearings. The paper book has been filed. Paragraph. Let this appeal retain its position in the list. Retain its position in the list.
Well, lord, 9, 10, and 11, well, it's same order.
Same order, separately. Will that any or to your benefit?
I do not know. Doubtful.
রাখো 3:30 রাখো 12টা কার একবার ডেকে দাও একটাই তো বাকি আছে রিটেন ইটস পজিশন বললাম মানে লিস্টে থাকবে
Lord, 12 is, my lord.
Item number 12.
Lord, I appear for the appellant 12 as well. My lord, here, my lord, there was a condition in a tender which said that every tenderer will have to, my lord, deposit a bank guarantee. Now, my lord, the successful tenderer, upon being awarded the tender, my lord, the bank guarantees of the others will be refunded. That is, my lord, the condition. Except, my lord, there's a caveat, my lord, in the tender itself, which says, if you are guilty of any suppression or misrepresentation of fact, my lord, while making your bid, then your tender amount will be forfeited. And, my lord, the tender amount was secured by furnishing a bank guarantee. Now, my lord, here, my lord, in the course of things, ultimately the tender was awarded to a different party. My lord, normally in the usual course, my lord, this money would be refundable to my lord.
Infotech.
Yes. But, my lord, here what happened is we came to know, my lord, that there's, my lord, a completely false disclosure and, my lord, made with regard to the eligibility criteria. So, my lord, ultimately we sought to invoke the bank guarantee. My lord, the writ petitioner went to court, my lord, obtained an order of stay. My lord, initially, my lord, the bank guarantee was invoked, my lord, without citing the reasons for invocation. My lord, classical line of judgments which says that you have to invoke according to the terms of the bank guarantee. Finally, my lord, the bank guarantee is extended. Within the period of extension, my lord, then, my lord, we go and invoke it, my lord, in terms of the bank guarantee. My lord, so it is within the period of extension. However, my lord, the learned single judge holds that since you have already awarded the tender to someone else, you have no right to really forfeit the bank guarantee of the other person. My lord, this is the short question.
What is the amount?
Well, it's 50 lakhs.
50 lakhs.
Well, the amount is not very big, but, my lord, it's a PSU, so, my lord, it's a question of, my lord, policy. That is why we are before you.
Amount is not big.
And, my lord, there is also a question of jurisdiction. My lord, we have raised the question of jurisdiction because nothing happened, my lord, in this court. So, my lord, The point of jurisdiction was raised but not decided.
Paper book?
Paper books have not been filed.
Well, this appeal is appearing for the first time today only.
First time today only.
Well, we can prepare and file paper.
Yes, do that. Do that.
If you
I khali memo-ta dao.
My lord, all the your lordship, if your lordship sees the appeal filed by them, all the documents are there. No, none of the documents
Your
are
lordship may
left out.
Then, my lord, hear out the.
Yes,
appeal on
any day your lordship can hear out.
This appeal is directed.
Even accept that later.
This appeal is directed against a judgment and order dated August 11, 2025, passed by a learned judge of this court in WPO 594 of 2024, being a writ petition filed by the respondent numbers 1 and 2 herein, by the order impugned. The appellant herein has been directed to return the concerned bank guarantee to the writ petitioners. Paragraph, we are told that all papers that were available before the learned single judge have been annexed to the stay application. We propose to hear out the appeal, treating the stay application as an informal paper book. All formalities are dispensed with. Since
No, your lordship, I represent the respondent number 1, the writ petitioner. No, not the one.
One and
my lord, I represent the writ petitioner, respondent number 1 and 2. And my lord, there was another respondent, my lord, GEM Authorities, Government E-Marketplace, though that respondent was deleted by the Honorable Single Judge.
Oh, deleted?
Yes, your lordship, they said that.
I used to appear for, my lord, Government E-Marketplace. Since Government E-Marketplace was not concerned with the consent tender, it was not struck.
No, my lord, very well, man.
Whatever the reason be, why then in the appeal cause title, it has been mentioned again?
The department, my lord, has not allowed, my lord. File it.
Anyway, so we have been struck off. ICICI Bank, you are appearing. Union is pro forma. So, since all relevant respondents are represented to the learned counsel, notice of appeal is deemed to be waived.
Wait, my lord, it is just that the letter dated 9th July 2024 is perhaps has been missed out. That forms a part of my affidavit. That one page.
Bring it, we'll take it. No problem.
Yes.
Bring it, we'll take it. Monday?
No, your lordship, except Monday, my lord, any other day. Monday, I'm not there in town.
Tuesday?
Yes, that's any other day.
Next Tuesday, date ta diye.
Tuesday কত তারিখ হচ্ছে?
Tuesday তোমার 18 তারিখ, sir.
Well, 18th and 19th, well, I mean, 18th, 19th.
All right, no problem.
20th onwards, any day.
20th?
Yes.
Stay application stands disposed of. But the stay application should be made available at the time of hearing of the appeal.
Deeply. 330 fixed matter item number 8.
Well, this is the MSME Malad matter.
And I appear for the company.
Well, I had last stopped yesterday.
Mr. Shah, just to warn you, you'll have 35 minutes today. Yes, 35 minutes. We'll rise at 4:15 for administrative reasons.
I may be able to conclude, my lord.
My lord, I'm led by Mr. Chaudhary.
Yes, next day.
My lord, your lordship will remember that, my lord, ultimately, my lord, I had shown your lordship, my lord, when initially a complaint was made, my lord, before the resolution professional, my lord, he comes up and says that there's MSME registration for the first time. Then, my lord, an application is filed, my lord, before the NCLT, my lord, saying that the plan cannot be considered because the plan is non-compliant. In fact, my lord, Rashmi, which is the respondent number 3, is disqualified. Why disqualified? Because A, it's a related party, my lord, hit by section 29A. And my lord, when my lord, they tried to say that no, you will still be safe because my lord, the corporate data entities are my lord, MSME enterprise, then my lord, he came and said it's MSME. And I've shown you, your lordship, the certificate that was first my lord, disclosed by my lord, the resolution professional, saying that it is incorporated in 1993. I come forward disclosing the certificate which says that the validity of the certificate is till June 2023. My lord, that is 2022, I'm sorry, June 2022. After that, my lord, automatically it elapses. And then, my lord, the resolution professional, in response to, my lord, what my application before the NCLT comes and files an affidavit. Well, I'll start from there once again, just to refresh your lordship's memory very briefly. My lord, here, my lord, your lordship will remember the affidavit that is filed, my lord, by the, my lord, resolution professional before the NCLT, my lord, very briefly, just my lord, very quickly, that your lordships will find at, my lord, volume 3, page 316. I've shown this to you, but my lord, just to establish the link. Your lord, page 316, if your lordships have it.
16.
My lord, date of commencement is 25th May 1993. The representation made, my lord, is that, my lord, this Uddur Aadhaar memorandum, well, it is still subsisting. That was the representation made by the resolution professional. Now, my lord, thereafter, my lord, in response, my lord, I, my lord, showed the certificate that, my lord, we had brought on record. My lord, that your lordship will find, my lord, is a certificate dated, my lord, 30th June 2020. I'm sorry, 321. My lord, this, my lord, we ultimately brought on record to show this is the actual, my lord, certificate. 321.
এতগুলো তুমি লাগিয়েছিলে টিকিট লাগিয়েছিলে তো হ্যাঁ তো না ঠিক Yes.
My lord, date of commencement is the same, but my lord, at the bottom of the page, your lordship will find this Uddur Aadhaar memorandum EOM certificate is valid till 30th June 2022. So, my lord, what, my lord, the RP had suppressed is, my lord, that certificate had already lapsed. And then, my lord, I showed to your lordship, my lord, the notices of or communication of, my lord, when electricity was disconnected. My lord, I have shown your lordship's page 322 and 323. Physical disconnection of electricity, my lord, on 8th August 2023. And, my lord, for the other unit on 22nd May 2019. These are at pages 322, 323. And, my lord, after, my lord, we make this, my lord, disclosure.
Yes.
My lord, saying that your certificate is, my lord, not valid because, my lord, it was valid only till 30th of June 2022. The resolution professional files a new certificate.
Oh, yeah.
My lord, here, my lord, you'll find that the certificates are coming fast and loose. 357. Now, my lord, 357, your lord, you'll find
Registration 25th August.
Yes, my lord. Now, my lord, what is very important here is, my lord, your lordship will find that, my lord, the classification of the type of enterprise, my lord, is, my lord, 23-24 medium, 24-25 medium. When, my lord, the industry has stopped running already. And, my lord, here your lordship will find at the bottom of the page, date of registration, date of Udyam registration is 25th August 2023, which is 3 days after the commencement of CRP. Now, my lord, as I told your lordship yesterday, my lord, after the commencement of CRP, my lord, all directors are suspended. My lord, all existing employees and their authority suspended. Anyone who acts can act only through the resolution profession. And my lord, here your lordship will see, my lord, there is no mention as to, my lord, who applied. Now, my lord, thereafter, my lord, apart from this certificate that is filed, now, my lord, very important, my lord, this certificate is not disclosed by the resolution. This is disclosed by the respondent number 3. ঠিক আছে আমি বলছি আমাকে বলতে দেন আমি জানি But I'm sorry, my lord. This is, my lord, 3 days after, but my lord, here, my lord, in view of section 17(1)(2) of the Insolvency Bankruptcy Code, my lord, there cannot be anyone else apart from the RP who can apply. RP does not say that he applied. Now, my lord, thereafter, my lord, Rashmi also files an affidavit. That is a 359. Now, my lord, Rashmi also, my lord, discloses another certificate with his affidavit, my lord, that is a 377. Now, my lord, please see 377. Here, interestingly, I showed your lordships that the date of incorporation is mentioned as 24th August 2023.
Yes.
And my lord, also your lordship will find that, my lord, the name of the enterprise at the top right hand, my lord, is mentioned as Jagdamba Industries Limited. Then there's, my lord, a mobile number of a person who is not the RP. And then, my lords, will kindly find, my lord, there's a bank number, bank account mentioned, State Bank of India, IFSC code 0000, account number 0000. And employment details, 1 male, 0 female, 0 others, total 1. Now, my lord, with these particulars, it is supposed to be a medium scale enterprise. Now, my lord, this is, my lord, what is coming out from the portal. Now, my lord, whoever approaches the MSME authorities and wants whatever certificate can get it. My lord, that is, my lord, what transpires. RP, my lord, goes, my lord, files a certificate which does not mention the last date till which it is valid. It is valid till 30th June 2022. Initial certificate disclosed by RP does not mention that. I come, bring that on record. RP then, my lord, comes forward and brings another certificate saying that, oh, there is a registration on 25th August 2023. Now, my lord, how, my lord, registration is obtained, who obtains the registration, no particulars. But at the same time, the successful resolution applicant, Rashmi, my lord, files another certificate. Says in incorporation in, my lord, August 2023, 1 employee, no bank account. Now, it is, my lord, this, my lord, these state of affairs which, my lord, became very startling. Now, my lord, after that, my lord, here, my lord, we then make a complaint, my lord, asking for cancellation of the registration. We make a representation to the MSME authorities, and, my lord, that your lordship will find, my lord, is a representation that we make at page 401. I'm sorry, my lord, that is the notification. 404. My lord, this is my complaint. I've shown your lordship the notification on the basis of which I make this complaint. Now, my lord, when I make this complaint, my lord, there's an inspection carried out and there's an inspection report that is filed on the 3rd of April 2025. My lord, that is 448. My lord, says that there was no signage on the unit premises. Locals reported that the unit has been closed for some years. All the machinery have been dismantled. No employee or worker was available in the unit premises. My lord, I filed the writ petition at this juncture. And, my lord, there's an order passed by the writ court on the 4th of April 2025. My lord, the writ court, my lord, ultimately says that in view of the provisions of the notification, there's already an inspection report on record. You give them a hearing and come to a final decision. My lord, that is the order of the writ court. I've placed that before you. And, my lord, on the same date, my lord, this is, my lord, the representation made by the, my lord, MSME authorities at page 453. My lord, this is where I had stopped yesterday. My lord, may I just take your lordship, my lord, back to that, my lord, communication. 4th April 2025.
453.
My lord, this is volume 4, 4th April. Now, my lord, please see this. My lord, this is, my lord, upon investigation, because, my lord, there is a complaint made my lord, there's an initial inspection report. Inspection is, my lord, forwarded to the district industries. My lord, district industries ultimately goes on the basis, my lord, looks at the portal, says that there's misrepresentation, and proceeds to direct them to apply for cancellation. My lord, please see the second paragraph. However, on physical verification of a unit by DIC Poshchim Bardhaman at its factory address, it has been found that the unit is closed for several years. All machinery have been dismantled. There are no employees or workers employed in the unit premises. Above facts have not been reported by you, and the existing UR clearly demonstrates misrepresentation of actual facts and the current status of the unit. Hence, you are advised to apply to the following link for cancellation of Udyam registration.
This I don't understand. Why can't the authority cancel itself? Why must it direct them to apply?
I do not.
It's like the court with, instead of cancelling the bill, directing the person on bail, you apply for cancellation of bail.
My lord, my lord, have not been able to understand this at all, because, my lord, there is provision in the notification for cancellation.
Yes.
Does not say that it has to be self-cancellation of a registration obtained on the basis of a self-declaration.
Anyway.
But, my lord, very important, my lord, this decision was never retracted from. Now, my lord, when, my lord, the writ court directs that, my lord, we give them an opportunity of hearing and then come to a decision, ultimately, my lord, the resolution professional makes a very detailed representation and response, my lord, on the 15th of April 2025. Now, the writ court order was on 4th April 2025. My lord, this, my lord, order of cancellation, which I have showed your lordship, is on the same date, 4th April 2025. But since, my lord, the writ court had said give them an opportunity of being heard in the matter, my lord, the resolution professional ultimately, my lord, comes forward and filed a detailed response. My lord, I will not trouble your lordship with that response, because ultimately, my lord, everything stated there according to us is false, and I shall show your lordship why. My lord, but my lord, I think I should, my lord, in all fairness, show your lordship. My lord, if your lordship comes to that response once, my lord, it starts at page, my lord, 454. My lord, if your lordships will see paragraph 10 at page 458. Paragraph 10, well, this is what the RP writes. It is pertinent to mention here that even after commencement of CIRP on 22nd August 2023, the cement plant of Jagdam Industries was operational until November 2023. And the steel plant was operational until 10th August 2023. Now, my lord, so far as this is concerned, my lord, this, my lord, is something, my lord, that ultimately is contrary to, my lord, the representations made with regard to the date of disconnection of electricity. And, my lord, also contrary to, my lord, what has been found on physical inspection. My lord, then, my lord, I'll show you, lordship, my lord, one or two other, my lord, contentions that have been forwarded. My lord, he goes on, my lord, to wax eloquent about, my lord, why it is still a MSME enterprises, but, my lord, this is contrary to what is there in the information memorandum. Now, I've told your lordship that, my lord, under law, the resolution professional is, my lord, obliged to publish an information memorandum. And that must contain all details of the industry. Well, that is at page 855, your lordship find. 855, that's it. 855 is the information memorandum. First thing, information memorandum does not, my lord, disclose that this is an MSME enterprise.
That was on which date?
Well, this information memorandum is published immediately. Yes, well, a document updated till 15th February 2024. Now, my lord, this is relevant. My lord, I should have pointed it out. My lord, your lordship is correct. My lord, this is very relevant because the CIRP was commenced on 22nd August 2023. Now, my lord, the information memorandum, which is updated till 15th February 2024, does not disclose that, my lord, this is ultimately, my lord, as a MSME unit. Now, my lord, so far as this is concerned, apart from the fact that there is no mention of the unit being a MSME unit, please, my lord, have a look at, my lord, page 854, 884.
884.
It's a part of the same information memorandum.
Starts at 855.
Yes. Eight 84. This is in volume 7. Internal page কত এটা? 884. Well, your lordship will find, my lord, 2 paragraphs before, my lord, the chart. Well, it says here, lordship will find there is no electricity in the steel division. RP has filed an application with the Honorable NCLT for relief. The same is pending. And then the next line, my lord, there is no electricity in the cement division since September 2023. Now, my lord, so far as this is concerned, my lord, this your lordship will find at 862, my lord, how, my lord, this is contrary to what he himself represents. Now, at 862, well, again a part of the same information memorandum. Well, kindly see, well, after the first paragraph, structural and rolling plant. Currently, last sentence, currently rolling mill is not in operation since July 2023. But, my lord, the RP in his affidavit, as I had pointed out to your lordship, my lord had said that, my lord, the cement plant is in operation till November 2023, steel plant in operation till August 2023. My lord, contrary stance. Now, my lord, if today there is no such representation made in the information memorandum, then, my lord, the question would be, my lord, what is the basis on which the RP, my lord, now represents that the MSME registration was, my lord, renewed, and, my lord, in any event, as I've shown, my lord, it is on the basis of self-declaration, my lord, which the portal accepts as, my lord, true, unless, my lord, proved to be untrue. Now, my lord, here thereafter, your lordship will find that, my lord, now that, my lord, this representation is made by the resolution professional on the basis of, my lord, what is stated, my lord, him and his affidavit. My lord, ultimately, my lord, the MSME authorities again, my lord, proceed to, my lord, pass an order. My lord, if your lordship now sees, my lord, here, my lord, there's a letter, my lord, we had asked the MSME authorities, my lord, to proceed, but initially, my lord, this was their response at page 614. My lord, High Court says, give them a hearing, come to a conclusion. The RP makes a representation which is completely false. The MSME authorities, upon being approached, well, as to what have you done in view of the High Court's order, well, at page 614, volume 5. Well, at volume 5, my lord, 614, your lordship will find receipt of your email dated 16th April 2025 is hereby acknowledged, and the points mentioned have been duly noted. My lord, these are the points by where we, my lord, show that, my lord, why the representation made by the RP are, my lord, false. However, the matter is now sub judice and is under the purview of NCLT, the process of CRP having already commenced. So, my lord, they basically say we will not decide anything. This is notwithstanding the direction of this Honorable High Court. Now, my lord, thereafter, my lord, we again approach, my lord, the High Court Well, in the meantime, there is another report that is now published by the authorities. Please see. I'm sorry, my lord. Yes, my lord. First, I approach the High Court in view of that stand taken by the MSME authorities. Your lordship will find an order of 13th June 2025 at my lord page 791, which is at volume 6. My lord, may I do something, my lord? After today's hearing, I'll make a compilation.
Very inconvenient.
Very, I mean, I just a kind of a convenience compilation only containing these documents. Page number put in here, actually compilation for the bar shifting from one volume to the other. Is possible. Page 791.
791.
Yes.
My lord, this is the second petition.
Yes, second.
My lord, we file a second petition in view of, my lord, the reluctance of the MSME authorities to produce. And my lord, this is, my lord, the direction. Petitioners pray for cancellation of MSME certificate issued in favor of respondent number 2. Whether the said certificate is liable for cancellation or not has been decided upon granting an opportunity to the certificate holder to file an affidavit in this regard. And my lord, then directions for affidavits are given. My lord, no affidavit filed.
Pending.
No affidavit filed. My lord, writ petition disposed of.
Writ petition disposed
Yes,
of.
that is, my lord, the order against which we are before your lordship.
Oh, I see.
So, my lord, all the opportunity granted to file affidavits, my lord, no affidavit filed. Instead, my lord, what happens is, my lord, now a very complicit MSME authority, my lord, comes and files, my lord, reports. My lord, that, my lord, is something that your lordship will find. My lord, this order was dated, my lord, 13th June. And, my lord, on the 11th of June, my lord, there was an order prepared by the MSME authorities, which had, of course, not been disclosed to court till then. It was brought on record later. That is, my lord, at page 952. Well, this is volume 7.
MSME filed that, MSME authorities.
একটা compilation না করলে অসম্ভব।
952.
Page 952.
952.
কটা ভলিউম আছে? 8টা না 9টা?
Let me come back, my lord, with a compilation. I can see, my lord, the inconvenience I'm causing the bench.
Actually, we are sorry because if you annex the two petition with the annexures, there's some duplications that is perhaps
No,
happening.
that's all right.
Not perhaps. It has obviously
Yes,
happened.
actually, we should apologize to you.
My lord, 952 is, my lord, an order, my lord, which had been prepared by the MSME authorities. In fact, my lord, briefly referred to in the NCLT without disclosing it, but brought on record subsequently.
Who is present there?
Now, my lord, please see here, my lord, very important. This is dated 11th June 2025. My lord, when the High Court, my lord, passes the order on 13th June 2025, the High Court does not notice this, my lord, order because, my lord, this is not brought on record. But, my lord, this is the order that, my lord, has already been passed. Now, my lord, very important. Let me just show your lordship this order. My lord, this is, my lord, the subject matter is inquiry for verification of details of Udyam registration of, my lord, Jagadamba Industries. Apropos the above noted subject and reference, I would like to inform you that an inspection has been conducted at Jagadamba Industries Limited Steel Manufacturing Unit at such and such, and Jagadamba Industries Limited Cement Manufacturing Unit at such and such, and also verified documents submitted by Technirman Ishpat Private Limited and Jagadamba Industries Limited. Technirman is my client. Jagadamba is, of course, the corporate debtor. Now, my lord, please see who are the persons present. Mr. Pradeep Kedia, Director of Jagadamba Industries, was present at both the unit premises during inspection, not the RP. He is the, my lord, suspended director my lord, who has no right to participate in proceedings. RP is not there. Now, my lord, what is observed? Observations of Jagadamba Industries Steel Manufacturing Unit, located at my lord Gopinathpur in Durgapur. No signage was found at any place on the unit site. Factory shed and machinery were found in rusted condition. Plant and machinery not in running condition. No power connection did not exist. And no employees, workers were found. Now, my lord, today, my lord, in view of these findings, my lord, the question is whether anyone can reasonably reach a conclusion that this was a running MSME unit. Now, my learned friends, my lord, say that it is investment in plant and machinery, investment made, my lord, years and years back. My lord, whether, my lord, it continues in the books or not, my lord, if the unit is not functioning, it cannot be MSME unit. Ultimately, my lord, MSME status is conferred because it is entitled to certain advantages, certain benefits. If you do not run the industry, if the industry is, my lord, defunct, my lord, then it can't have the MSME status. Then, my lord, kindly see, my lord, the next part. Observance of Jagadamba Industries Limited Cement Manufacturing Unit, located again at, my lord, Bidhan Commercial Complex in Durgapur. Again, signage was found on the unit site. Factory shed and machinery were found in rusted condition. Plant and machinery not found in running condition. Power connection again did not exist. No employees were found. Now, my lord, thereafter, my lord, please see page 953. This is the self-declaration. As per Udyam portal, it appears that investment in plant and machinery and turnover of Jagadamba Industries is as follows. Now, my lord, 23-24, my lord, they are supposed to have, my lord, a written down value of plant and machinery of 23 crores 21 lakhs. Koto eta? No, 232 crores. 232 crores. Oh, 2 crores 32 lakhs 19,071. And there were turnover of, my lord,
23 crore.
23 crores 21 lakhs 90,071. And, my lord, the turnover is, well, at 14 crores 87 lakhs 92,000. No, 1 crore 48 lakhs 79,293.
1 crore 48.
Now, my lord, may I just ask myself this question? Well, if the report is there are no employees, well, there is no electricity, there is no, my lord, operational plant and machinery. Plant and machinery dismantled in some cases in a totally rusted condition someplace. And, my lord, the representation made by local authorities, the unit is lying closed for many years. My lord, can it, my lord, reasonably be believed that, my lord, there is, my lord, in fact, turnover? So, my lord, the self-declaration is obviously, my lord, a fraudulent declaration. Two things. My lord, the self-declaration is wrong and it is made by not the RP, who is the only person who could have made the declaration after the commencement of CIRP. Then, my lord, kindly see. Now, my lord, please see, my lord, another thing, very interesting thing. Your lordship has seen that the certificate which was annexed by, my lord, the RP showed that it was registered as a medium enterprise. My lord, here, my lord, for the year 2023-2024, it's shown as small. When the migration took place, my lord, we do not know. My lord, I shall show your lordship the balance sheet. Now, please see, my lord, the next line. Online portal for Udyam registration captures depreciated costs as on 31st March each year of the relevant previous year. My lord, depreciated cost of machinery, my lord, which is not there. I understand that machinery is running, machinery is functional, my lord, then you take a depreciated value. My lord, today, my lord, I am running a car. My lord, year after year, my lord, when I go to renew the insurance of the car, my lord, there's an insurance declared value, which, my lord, with each year, my lord, goes down. My lord, so, my lord, it is only in respect of an operational piece of machinery, then one can, my lord, ultimately take into account the value. If the machinery is junked, if the machinery cannot be used, if it is dismantled, my lord, how can you take the written down depreciated value? And then, your lordship will please see, my lord, then clause 5. Then, my lord, next is Roman 2. The data of investment and turnover either gets auto-filled or fetched from the income tax department for those enterprises who have filed IT and GST return. As letter received from WBSETCL number such and such, dated 15th May 2025 against our request letter, with a memo such and such, the power connection of Jagadamba Industries steel plant located such and such was disconnected permanently on 9th August 2023, that is before my lord the CIP commencement date, due to non-payment of electricity bill. Letter written received from India Power Corporation Limited, dated 11th June 2025 against our request letter, power connection of Jagadamba Industries Limited cement plant located at Bidhan Commercial Complex was disconnected permanently on 27th November 2023 due to non-payment of electricity bill. But my lord, power connection, my lord, is disconnected. But even if one says, my lord, power connection in, my lord, one of the units existed till November 2023, but there is, my lord, no machinery, no workmen, no production. Now, my lord, here, if your lordship will now also have a look at, my lord, the balance sheet, my lord, that has been filed by the company. My lord, that starts at, my lord, if your lordships have volume 7, that starts at page 909. 7.
909.
909. This is a part of, my lord, the balance sheet, my lord, for the year. কোন বছরের ব্যালেন্স শিটটা? This is on August 2023.
এটা শুরু হচ্ছে কোথায়? August 2023.
Yes.
885.
Yes. August 2023. Now let's please come to 909.
Yes.
Well, at Roman 17, well, this is what the auditors will comment. The creditor or lender of the company has, I'm sorry. (909) Roman 17. The creditor or lender of the company has initiated proceedings against the company before the NCLT for recovery of their dues. Considering this and considering the company's poor financial position, we do not foresee the company can continue as a going concern. 915 thereafter.
Yes.
915, if your lordship will see, my lord, 1B and 1D. My lord, these are all notes of the auditor. And signed by the director of the company. My lord, please see 91B. The property, plant and equipment have not been physically verified by the management during the year, hence could not be commented upon. Then, my lord, how do you ultimately reach a conclusion that this is the depreciated value of the machinery? And then D. As explained, the company has not revalued any of its property, plant and equipment and tangible assets during the year. Now, my lord, if today this is, my lord, the position of the balance sheet, what is the kind of inquiry that was conducted by the MSME authorities to reach the conclusion that yes, although there is no signage, although there is no business, although there is no production, although there is no power connection, although there are no employees, well, this is still, my lord, an MSME, my lord, registered unit.
দেখো কবে দেবে দেখো দেখো মানডে অন্য কিছু PF doesn't necessarily stand for Provident Fund. It also stands for photo finish. नहीं तो 3:30 on Monday.
Well, 17th, 18th, and 19th, well, I'm in some difficulty these 3 days. 17th is Monday.
20 तारीख देखो Thursday. No, it will be a different bench. Then it will take you to 24th.
24th. I'll come back because my 17th, 18th, 19th, I'm in serious difficulty. I can.
24th.
Oh, well, 24th, well, Mr. Banerjee is opposing me in Delhi.
Outside somewhere. Outside.
25th, my lord.
25th.
देखो 25th. একবারে 25th December করে দাও। লেখো। Mr. Shaha, learned senior counsel representing the appellant, resumes his argument but does not conclude. Appellants. Paragraph as requested, let this matter be listed again on November 25, 2025, marked 3:30 p.m. You will take not the entire.
No, Mala, I'll finish. Mala, I'm very close.
Then who will start?
Finishing.
Mr. Chaudhary will be.
I feel there will be something to say and there is some substance.
You decide amongst yourselves who will. Somebody should argue.
Mr. I am relieved of my.
My learned friends have assured the court that NCLT has made an observation that till the matter is decided.
Yes, that's what we were told.
That's it. ঠিক আছে
Recording as such.
তো ওরাই বলেছে জিষ্ণু চৌধুরী নিজেই বললো ঠিক
There's no